Hey guys, tonight we're stepping into the smoky half-light of a medieval manor house where a young bride stands before a wooden chest, her fingers trembling as she touches the iron lock that now holds everything she owns. The air smells of beeswax and rushes scattered across cold stone floors. Outside, church bells mark the hour of her wedding, and with each chime, her legal existence is quietly, irrevocably changing. She doesn't know it yet, but the moment she speaks her vows, the law will perform a magic trick, making her disappear as an independent person while simultaneously creating new rules about who gets to touch her silver cups, her embroidered linens, her late father's coins. The story may solve mysteries you never had an explanation for about why marriage meant something so different for women than for men, why widows held strange power in medieval society, and why your great-great-great-grandmother's inheritance rights looked nothing like her brother's. So, before you explore the story with me, please take a moment to help me subscribe to the channel, like and share this video, or maybe leave a comment below, but make sure you do it when you really like what I bring to you. Tell me where you're watching from tonight, or which historical period makes you most curious. I love reading your thoughts when I wake up. Now, let's keep the lights as soft as possible, turn on the fan for a gentle sound to help the story feel more emotional, and let's embark on tonight's journey together. You're standing in that bride's slippers now, feeling the weight of the moment. The year is 1347, and you're in the English countryside, though the scene plays out similarly whether you're in France, the German states, or the kingdoms of Iberia. Your father spent weeks negotiating this marriage, and part of those negotiations involved something called your marriage portion, the property, cash, or goods he'll transfer to your new husband's family. You've watched your mother pack your dower chest with linens you spent years embroidering, silver spoons that belonged to your grandmother, a bolt of crimson wool that cost more than a servant earns in 6 months. These objects feel like yours. They carry your history, your labour, your family's love. But the law sees them differently. The medieval legal concept of a marriage portion worked like this. Your father or guardian would promise a certain value, let's say 20 marks in silver, 3 milk cows and rights to collect rent from a small tenant farm, to your future husband. This wasn't a gift to you. It was compensation to the man who would now feed, clothe, and house you for the rest of your life. Assuming he outlived you, in exchange, your husband's family would promise you a dower, typically 1/3 of your husband's lands and property, which you'd receive if he died before you did. It's a swap that treats marriage like a business merger, because in many ways, that's exactly what it was. You watch your father clasp hands with your future father-in-law, their agreement sealed before witnesses. The marriage portion might include a working mill on the river, but you'll never personally control that mill's income. Once you marry, your legal identity undergoes what medieval lawyers called coverture. You'll be covered by your husband's legal personhood. It's as if the law places a heavy cloak over you, and suddenly, when people look your way, they see only your husband's shape. You cannot sign contracts without his permission. You cannot sue or be sued in your own name in most circumstances. You cannot sell property you brought into the marriage. Even debts you owed before the wedding become his debts now. The transformation is so complete that a legal manual from 1290 describes husband and wife as one person in law, except that person is always the husband. But here's where it gets interesting, and where historians still argue whether medieval law was cruelly restrictive or accidentally protective. That same coverture that erases your independence also shields you from certain liabilities. If your husband runs up gambling debts, creditors can't seize your dower rights, the property reserved for your widowhood. If he's convicted of a crime, your promised 1/3 generally remains untouchable. The law treats married women as legally incompetent, similar to children, which is patronising and limiting. But that incompetence sometimes functions as a legal shield. You can't be held fully responsible for contracts signed under your husband's influence because, technically, you're not considered capable of independent legal action. It's a double-edged sword that cuts both ways. And medieval women learn to grip the handle carefully. Your wedding day arrives with all its ceremony. You stand before the church door. Marriages happen outside initially, at the church threshold, before moving inside for the Mass, and you repeat words in Latin you barely understand. Your husband places a ring on your finger, first on your thumb while saying, "In the name of the Father," then your index finger for "and of the Son," then your middle finger for "and of the Holy Spirit," finally resting on your ring finger with "Amen." This progression isn't just religious theatre, it's a public performance of transfer. Your father's authority over you is officially passing to your husband, and everyone watching knows exactly what that means for your legal standing. The feast afterward is lavish if your family can afford it. Roasted swans, honeyed wine, a travelling musician who plays songs that make the older women weep with nostalgia. But beneath the celebration, a massive property reorganisation is occurring. The manor house you'll now call home belonged to your husband's father, who's still alive, which means your husband doesn't fully control it yet either. Medieval inheritance usually passed from father to eldest son, but not at the moment of marriage, only at death. So you're entering a household where your father-in-law holds the real power. Your husband waits in a kind of legal adolescence despite being 24 years old, and you occupy the bottom rung of authority despite technically being the wife of the heir. You learn quickly that the household keys, literal iron keys to the storage rooms, the wine cellar, the locked chests, are held by your mother-in-law, and she'll decide when and if you're ready to receive them. Those keys represent domestic authority, the management of household resources, and they're passed woman to woman according to family politics more than any written law. One quirky historical detail: in some regions, the wedding would include a ritual where the bride's shoes were removed and given to the groom, who'd tap her lightly on the head with one, symbolising his authority. Historians debate whether this practice was widespread or regional, but it shows up in enough medieval art and literature to suggest it wasn't rare. Imagine that, being ceremonially bonked with your own shoe to remind you who's in charge now. Medieval people loved their symbolic gestures, even the vaguely insulting ones. The marriage portion your father provided is now deployed. If it included land, that property is absorbed into your husband's holdings, and he'll collect its rents and profits. If it was cash, he might invest it in livestock or use it to pay down debts. You have no say in these decisions. The law assumes that as his wife, you benefit from whatever choices he makes. If the investments prosper, you'll enjoy a more comfortable home. If they fail, you'll tighten your belt alongside him. But alongside is doing a lot of work in that sentence, because the consequences of his financial mistakes fall on you without granting you any power to prevent them. And yet, in this very constraint, the seed of your future freedom is planted. That dower right that promised 1/3 of his property if he dies first is waiting in the legal shadows like a patient crow. You don't think about it much during the early years of marriage when you're both young and a death seems distant. But it's there, written into the marriage contract, witnessed by the community, and surprisingly difficult for anyone to revoke. Medieval law might treat you as legally invisible during marriage, but it simultaneously prepares for the day when you might outlive your husband and need independent resources. The system expects widowhood, it plans for it, and in doing so, it creates a strange category of women who will eventually possess more autonomy than they ever had as daughters or wives. For now, though, you're learning to navigate a legal identity that exists only in relationship to men. First your father, now your husband, your property adjacent, entangled with resources you cannot directly control, waiting for circumstances to shift in your favour or crush you entirely. You wake on your first morning as married woman and reach instinctively for the small purse you've kept under your pillow since childhood. 3 silver pennies your godmother gave you, a token you've treasured for years. Your fingers find the familiar leather, but something has changed overnight that you can't quite see. Those coins are still physically yours to hold, but legally they've transformed into your husband's property. He could walk into this room right now, take that purse, spend every penny on a new saddle or a round of ale for his friends, and you'd have no legal recourse whatsoever. The law has performed its vanishing act, and you're living inside the aftermath. This is coverture in its full, suffocating operation, the legal doctrine that defined married women's lives across medieval Europe. The word itself comes from the Old French couverture, meaning covering or protection, which tells you everything about how the law viewed this arrangement. You're not disappeared out of cruelty. You're protected beneath your husband's legal identity, the way a child might shelter under a father's cloak during a rainstorm, except you're not a child. You're a grown woman with thoughts, skills, memories, and desires. And the law has decided none of that matters enough to grant you separate legal personhood while married. The English common law tradition, which emerged clearly by the 13th century, stated this principle with brutal clarity. By marriage, the husband and wife are one person in law. That is, the very being or legal existence of the woman is suspended during the marriage. Sir William Blackstone would later summarise it perfectly in his 18th century commentaries. But he was describing rules already ancient by his time. A married woman, a femme couverte in legal French, couldn't own property separately from her husband. She couldn't write a will without his permission. She couldn't enter into contracts that would bind her independently. She couldn't sue someone who wronged her without her husband joining the suit. If someone owed her money from before the marriage, that debt became her husband's to collect. If she committed a crime in his presence, the law might even assume he commanded her to do it, shifting responsibility to him because surely she had no independent will. Historians still argue whether coverture was designed primarily to consolidate family resources efficiently or to deliberately subordinate women, and the answer is probably frustratingly both. Medieval society organised itself around households, not individuals. The household was the economic unit, the political unit, the social unit. Having 2 separate legal entities trying to manage the same household resources seemed, to medieval legal minds, like putting 2 captains on one ship, a recipe for chaos. Better, they reasoned, to have clear hierarchy and unified control. That this reasoning conveniently placed men in the captain's position while women swabbed the deck wasn't seen as unjust. It was simply the natural order, reinforced by scripture, classical philosophy, and centuries of tradition. But you're learning that coverture's reality is more complex than the stark legal theory suggests. Yes, your husband technically controls all marital property, but daily life requires negotiation. He's away from the manor frequently, riding to the market town, attending the Lord's court, checking on distant fields. While he's gone, you're managing the household, directing servants, deciding which chickens to slaughter and which to keep for eggs, allocating the grain stores to last until harvest. This isn't legal power, it's practical necessity. And in that gap between law and practice, medieval women carved out space for agency. You discover that certain transactions allow you to act semi-independently. If your husband authorises you to conduct specific business, say selling surplus wool from the estate, you can do so in his name, and those transactions will hold. Merchants in town know you, trust your judgment, and don't demand your husband appear in person for every minor deal. This informal economic participation doesn't grant you legal rights. but it gives you experience, relationships, and knowledge that might prove useful later. You're learning the price of grain, the trustworthiness of various buyers, the seasonal rhythms of commerce. Should you outlive your husband and become a widow with actual legal authority, you won't be starting from complete ignorance. There's also the matter of your paraphernalia, a wonderful legal term for the personal items considered so closely associated with your person that they existed in a grey zone. Your clothing, your jewellery, your prayer book, these items were theoretically your husband's property, but custom often protected them from his creditors and from seizure. A wife's best gown and her religious items occupied a special category, acknowledged as hers in some meaningful sense, even when the law said otherwise. It wasn't much, but in a system that erased your legal existence, even small recognitions of your continued personhood mattered. One quirky medieval practice, in some regions, if a husband tried to sell his wife's best dress or her wedding ring, community pressure and local custom might intervene, treating such acts as shameful even if technically legal. The law was one thing, neighbourly opinion was another, and both shaped medieval life. You watch your husband make decisions about property you brought to the marriage, and sometimes his choices mystify or frustrate you. He's decided to lease your father's mill, the one that was part of your marriage portion, to a tenant you don't trust. A man known for cutting corners and letting equipment fall into disrepair. You mention your concerns, but he dismisses them. It's handled, he says, and legally, he's right. It is handled by him, without your input being required. If the mill deteriorates under the tenant's neglect, the loss affects your family's resources, but you had no power to prevent it. This is the daily indignity of coverture, watching someone else manage your contribution to the marriage while you're relegated to observer status. Yet, here's a weird paradox that kept medieval legal scholars debating. Because you're legally invisible, you're sometimes weirdly protected. Imagine your husband buys goods on credit and fails to pay. The merchant can sue your husband, seize his property, even have him imprisoned for debt in some circumstances. But your dower rights, that 1/3 of his estate reserved for your potential widowhood, remains largely untouchable. The law that erases your independence during marriage simultaneously ring-fences resources for your future survival. It's as if the system knows it's creating vulnerability and tries to compensate by guaranteeing you won't be left utterly destitute if he dies. Whether this trade-off is fair is exactly what historians still argue about over academic conference coffee. There are also regional variations that complicate the picture, in parts of France operating under customary law rather than Roman law influence. Married women retained slightly more control over property they brought to the marriage. In some Italian city-states, wives could conduct business more independently if they were from merchant families with specific guild privileges. In Scandinavia, married women held certain inheritance rights their English sisters couldn't dream of. Medieval Europe wasn't legally uniform. Local customs, regional traditions, and competing legal systems, church law versus secular law, for instance, created a patchwork where a woman's rights might change dramatically if she moved 50 miles east. You're living in this patchwork trying to understand which rules apply to you specifically. When your husband's cousin comes to visit and casually mentions that women in his district can make wills independently, you feel a pang of something. Envy, maybe, or just exhausted frustration. Why does the accident of your birthplace determine whether you're legally capable of deciding who inherits your grandmother's ring? But medieval people didn't think in terms of universal rights. They thought in terms of local privileges, inherited customs, and specific relationships. You weren't a citizen with rights. You were John's wife from the manor near the oak copse, and your legal situation flowed from those particular circumstances. The transformation coverture works on your identity goes beyond property. Even your name starts to blur. People increasingly call you Goodwife Margaret, or simply the Smith's wife, rather than using your family name. In legal documents, you appear as Margaret, wife of John Smith, with your existence defined entirely through marriage. If you have children, you'll be further reduced to John's mother in casual conversation. The law's erasure of your independent legal personhood echoes through social life, language, and daily identity. You're becoming an appendage, a modifier, a relationship rather than a person. And yet, and this is where the emotional complexity deepens, you also feel, sometimes, a strange relief. The weight of financial decisions falls on your husband's shoulders. If harvests fail, if tenants don't pay, if investments sour, the community judges him, not you. You're spared certain pressures and anxieties that come with legal responsibility. Is this protection or infantilization? The answer shifts depending on your mood, the season, your husband's current behaviour, and whether you ate enough breakfast. Medieval women weren't unanimous in their feelings about coverture because human beings are never unanimous about anything, especially complex systems that offer both constraints and comforts. Tonight, as you drift towards sleep, you think about that purse under your pillow. The coins are still there, still physically in your possession. Your husband hasn't asked about them, might not even know they exist. The gap between legal theory and daily practice is where you live now, navigating a system that erases you in writing while acknowledging you're still here, still thinking, still making countless small decisions that keep the household running. The law might call you invisible, but you can feel your own pulse, your own breath, your own stubborn existence continuing despite what any legal text claims. You're standing in the churchyard on a grey November morning, watching them lower your husband into the cold ground. The priest's Latin washes over you like distant rain, and you feel, what? Grief? Certainly. Relief? Perhaps, though you'd never admit it aloud. Fear about the future, absolutely. But beneath all those expected emotions, something else stirs. A strange, guilty awareness that your legal existence is about to snap back into focus like a candle suddenly lit in a dark room. Your husband's death is tragedy and liberation, braided together so tightly you can't separate the strands. Welcome to widowhood, the most paradoxical status a medieval woman could occupy. The transformation begins almost immediately. Within hours of the burial, you're no longer John's wife. You're the widow Smith. And that shift carries enormous legal weight. Under coverture, you disappeared into your husband's legal identity. Now, with him gone, you emerge like a swimmer breaking through water's surface and gasping and disoriented, but undeniably present again. You can own property, you can sign contracts, you can sue and be sued, you can write a will, you can conduct business. You've become, in the eyes of medieval law, something you haven't been since childhood, a legal person with agency and rights. It's intoxicating and terrifying in equal measure. The specific rights you now hold depend heavily on your dower, that 1/3 of your husband's property that was reserved for exactly this moment. Remember that promise made on your wedding day, witnessed by the community, written into marriage agreements? Now it activates. You're entitled to 1/3 of all lands your husband held during the marriage, for the rest of your life. Not ownership in the modern sense. You can't sell it or bequeath it. But you have the right to live on that land, collect its rents, harvest its crops, and enjoy its income until you die. It's called a life estate, and it's your shield against destitution. The practical reality of claiming your dower can be smooth or nightmarish depending on your relationship with your husband's heirs. Your stepson, John's son from his first marriage, is now the legal owner of the remaining 2/3 of the estate, and his eyes narrow when he calculates how much revenue he's losing to your dower rights. You see him doing the math. If you live another 30 years, that's 3 decades of income flowing to you instead of him. Some stepsons in your position would be patient and respectful. Others would make life so miserable for their father's widow that she'd flee the property or remarry quickly just to escape the tension. You're fortunate, your stepson is decent, though not warm, but you hear stories from other widows that make your blood run cold. Medieval law provided that widows should receive their dower within 40 days of their husband's death, during which time they could remain in the main house. This period was called quarantine, though it had nothing to do with disease. It meant 40 days of grace while you sorted out where exactly you'd be living and what resources you controlled. In reality, the process often dragged on much longer. Estates had to be assessed. Boundaries had to be walked and witnessed. Sometimes multiple properties had to be divided, with 1/3 of each parcel allocated to you. If your husband died owing debts, creditors might challenge your dower, arguing their claims came first. You'd need to hire a lawyer, yes. Medieval widows could and did retain legal counsel and navigate church courts or manor courts or royal courts, depending on the nature of the dispute. Historians still argue whether the dower system was genuinely protective of women or merely a consolation prize that kept widows from starving while still denying them full property rights. The truth probably splits the difference. Without dower rights, widows would have been completely at the mercy of their husband's heirs, many of whom had no biological or emotional connection to their father's second or third wife. Dower guaranteed at least minimal support, but 1/3 isn't 2/3, and it definitely isn't the whole estate. Meanwhile, your late husband's heir gets the lion's share, and if you had daughters, they might receive small marriage portions but rarely inherited land directly. Sons inherited, daughters married and brought their inheritance to other families. Widows lived on fractions, yet those fractions could be substantial if your husband was wealthy. A widow who'd been married to a prosperous knight or merchant might control more property and income as a widow than many married men possessed. You hear about the Dowager Countess 2 estates over. She's managing 6 manors, collecting rents from hundreds of tenants, hiring and firing stewards, and making decisions that affect entire villages. She wears her widow's black-like armour and negotiates with the king's officials as an equal. That's the potential of wealthy widowhood. Real power, acknowledged authority, freedom from coverture's suffocation. One quirky historical detail. Wealthy widows often chose to remain unmarried for decades, precisely because they understood that remarriage would erase their legal personhood again. Why voluntarily step back into invisibility when you'd finally escaped? You're not a countess, but your dower still grants you meaningful independence. You have a section of your late husband's land, a cottage on the property, and income from tenant rents. It's not luxury, but it's yours, legally, undeniably yours, in a way nothing has been since you were a girl. You wake up in your widow's cottage and make decisions. This field will be planted with barley. That tenant's rent can be delayed until after harvest because his wife just had twins. The stone wall needs repair before winter. These aren't your husband's decisions filtered through you. They're yours, made by you in your own name. The first time you press your own seal into wax on a legal document, your hand trembles slightly. That seal represents you, not your husband, not your father. You. The social position of widows was equally complex and contradictory. On one hand, widows commanded respect as property holders and household heads. Medieval culture venerated the biblical widows, Anna, Judith, the widow who gave her last mite, and church teaching emphasized that widows deserved protection and honor. On the other hand, widows also attracted suspicion and mockery. They were women operating independently in a society that preferred women supervised by men. They were presumed to be sexually experienced but without legitimate outlet, which made them objects of bawdy jokes and insinuation. Literature portrayed widows as either saintly and chaste or conniving and lusty, with little middle ground. You navigate these stereotypes carefully. maintaining modest dress and behaviour while still asserting your rights when challenged. You're also aware that your widowhood makes you vulnerable in ways that have nothing to do with law. A woman living alone, managing property, visible in markets and courts, she attracts attention, and not all of it benign. There are men who see a widow's independence as opportunity, either for legitimate remarriage or for exploitation. You learn to be cautious, to travel with companions, to keep your door barred at night. The freedom of widowhood comes with the responsibility of self-protection that your husband's presence, for all its suffocating legal control, once provided automatically. Some widows in your acquaintance have formed small communities, living near each other, sharing resources and protection. You gather with them sometimes, and the conversation ranges from practical, how to get fair prices at market, which bailiff is honest, to philosophical. One widow jokes darkly that she's been married to the law now, free to make her own decisions but still constrained by what society permits a woman to do. Another says quietly that these years of widowhood are the first time she felt like herself since childhood, that the grief of losing her husband is real, but so is the relief of finally having space to breathe. No one contradicts her. You all understand. The church offers you a path some widows take. You could retreat from the world entirely, joining a religious community or taking private vows of chastity while remaining in your home. Chaste widows who dedicated themselves to prayer and charitable works were celebrated in medieval culture as living saints. They combine the purity of virginity with the experience of marriage, occupying a special spiritual category. But religious widowhood would mean surrendering the independence you've just gained, submitting to a different set of rules and authorities. Some women find that path genuinely fulfilling. You're not sure you would. Instead, you're learning to navigate widowhood as a secular state, managing property, making contracts, defending your interests, and slowly building a life that's shaped by your choices rather than someone else's authority. It's not the life you imagined as a young bride. It's harder, lonelier, and more precarious. But it's also more yours than anything you've known before, and that makes it worth defending fiercely. As you fall asleep tonight in your widow's cottage, you realise that you've become, through the accident of your husband's death, what medieval society rarely allowed women to be: independent. The word tastes strange and powerful in your mouth, like wine you weren't supposed to drink but did anyway. You're sitting across from your late husband's steward, a thin man with ink-stained fingers who's explaining the estate divisions with barely concealed impatience. He keeps referring to something called the custom of the realm, as if those words should clarify everything. Finally, you interrupt. Just tell me plainly, what am I entitled to? He sighs, unfurls a piece of parchment, and begins listing properties. This manor's Southfield, 1/3 of the mill's annual income, the cottage where you're currently living, rent from 4 tenant families. As he speaks, you're doing your own calculations, and a number keeps surfacing. 1/3, everything is 1/3. It's not random generosity or arbitrary custom, it's the dower right, the mathematical heart of medieval widowhood, and it's about to define the rest of your life. The rule of thirds wasn't invented casually. It emerged from centuries of legal evolution across medieval Europe, crystallizing into custom that became as binding as any written statute. The logic went something like this. A married couple operated as one economic unit, pooling resources to build a household. If the husband died first, and, statistically, given the dangers of warfare, accidents, and occupational hazards, he often did, the wife needed support. But the husband's heir, usually his son, also had legitimate claims to the property, especially land that had been in the family for generations. The 1/3 compromise split the difference, enough for the widow to live with dignity, but not so much that the heir's inheritance was crippled. It wasn't perfect justice, but medieval law rarely aimed for perfection. It aimed for stability, continuity, and the prevention of destitute widows becoming burdens on church, charity, or community, poor relief. In England, this dower right was so fundamental that it existed automatically. You didn't need it written into a marriage contract because the law presumed it. The moment you married, you acquired an inchoate dower right, a legal claim that slept dormant during your husband's life, but sprang into full existence at his death. Your husband couldn't sell land during marriage without your consent if that sale would diminish your eventual dower. Imagine that. A married woman whose legal existence was supposedly covered by her husband's identity could still block his property transactions. The law required him to bring you before a court official who would examine you privately, away from your husband's presence, to confirm you agreed to the sale freely and understood you were surrendering future dower rights to that property. This examination, called separate examination or private examination, acknowledged that you remained a person with interests distinct from your husband's, even while coverture theoretically erased you. Historians still argue whether these private examinations actually protected women or merely created theatrical consent for predetermined decisions. The idealistic view says it gave wives real veto power over destructive financial decisions. The cynical view notes that medieval women had limited ability to resist husbands who pressured them privately before any court appearance. The evidence supports both interpretations because, like everything in medieval life, outcomes varied wildly based on personalities, local officials' diligence, and sheer luck. Some courts took the private examination seriously, asking probing questions to ensure consent was genuine. Others rushed through the formality in minutes, collecting the wife's yes like a clerk stamping documents. Your own dower isn't just 1/3 of land, it's 1/3 of all lands your husband held at any point during the marriage. This detail matters enormously. If he owned property when you married, then sold it 5 years later, you still have dower rights to that property. The buyer took the land subject to your inchoate claim, knowing that if your husband predeceased you, you could return demanding your 1/3 life estate. This rule made widows powerful and occasionally inconvenient. You hear about a widow 3 villages over who showed up at a property her late husband sold 15 years earlier, waiving the marriage contract and demanding her dower portion. The current owner was livid. He'd paid good money and assumed the transaction was clean, but the law sided with the widow. Medieval property law wove widows' claims through every transaction like threads in tapestry, impossible to remove without unravelling everything. The 1/3 wasn't always equal thirds in practice. If your husband owned 10 fields of varying quality, he wouldn't necessarily get the best 3 or the worst 3. Instead, assessors would try to divide the property so your third generated roughly 1/3 of the total income. You might get 2 excellent fields and half interest in a mill, while the heir received more parcels but of lesser value. These divisions required careful measurement, often involving community members who walked boundaries, stuck poles in the ground marking divisions, and testified to the fairness of the split. It was medieval surveying meets property mediation, and it didn't always go smoothly. You've heard stories of disputes lasting years, widows claiming they'd been cheated with poor land, heirs insisting the widow's portion was too generous, assessors accused of bias. One quirky medieval practice that shows up in regional variations, in some areas, the widow had the right to choose her dower portion first, selecting which third she preferred. In others, the heir chose first. All the portions were assigned by community elders. These details could dramatically affect your quality of life. If you got to choose, you'd pick lands close to town, easily managed, with reliable tenants. If the heir chose first, you might end up with the distant marsh field that flooded every spring and tenant families known for missing rent payments. The variance in local customs meant 2 widows of identical wealth might experience vastly different standards of living based purely on which manors traditions applied. Your dower is also temporary in a crucial sense. It's a life estate, not fee simple ownership. You can't sell the land, can't mortgage it, can't bequeath it to your children. You hold it for your lifetime only, and when you die, it reverts to your husband's heir or his descendants. This limitation protected family land from permanent fragmentation. It meant the estate would be reassembled after your death, maintaining its value and coherence for future generations. But it also meant you couldn't build dynastic wealth through your dower. You could live comfortably, perhaps even well, but you couldn't transform your dower into a power base that would outlast you. Medieval law gave widows survival, not dynasty. The church played an interesting role in dower rights. Canon law, the law of the Catholic Church that governed marriage across medieval Europe, strongly supported dower, treating it as the wife's reward for her consent to marriage and her service to the household. Church courts would hear dower disputes and generally favoured widows over heirs when the law was ambiguous. This wasn't pure altruism. The church wanted to prevent destitute widows from burdening monastic charity, and supporting dower rights served that goal. But the theological justification mattered too. Medieval Christianity taught that marriage was a partnership, even if an unequal one, and the dower represented the husband's obligation to provide for his wife beyond death. Failing to protect a widow's dower was, in the church's view, a kind of theft, taking what rightfully belonged to her through divine and human law. You're also discovering that dower rights could be negotiated and modified through marriage contracts, especially among wealthier families. Your own marriage included the standard common law dower, automatic 1/3, but you hear about noblewomen whose marriage contracts specified different arrangements. Some received specific properties by name rather than a fractional share. Others got fixed annual incomes instead of land. These customized dowers could be more or less generous than the standard third, depending on what the families negotiated. The trend, you'll later learn, is moving toward these negotiated arrangements, which lawyers call jointure. But that's a development that will complicate widows' lives in ways you can't imagine yet. For now, you're living in the simpler era when most widows could count on their automatic third, predictable and secure. Tonight, you're walking the boundaries of your dower land, literally pacing the fields that will sustain you. Your stepson walks with you. It's customary for the heir and widow to jointly witness the division, and you're both quiet, calculating. He's wondering if you'll live 10 years or 30. How long until this valuable land returns to his full control? You're wondering if the income will suffice, if the tenants are honest, if you'll manage this property wisely enough to live with dignity. The 1/3 rule brought you both here, to this twilight walk across fields, bound together by law and economic necessity, though you share no blood and little affection. It's the medieval compromise in human form, enough for everyone to survive. Not quite enough for anyone to feel they've won. You're walking through the narrow streets of a market town on a drizzly Tuesday morning, dodging mud puddles and pigs that root freely between the buildings. The air smells of fresh bread, tanning leather, and the less pleasant realities of medieval sanitation. You're here to meet with a cloth merchant about purchasing wool, and as you approach her stall you notice something remarkable. The sign above reads Agnes Kemper, merchant, with no mention of a husband. Agnes greets you warmly, her fingers stained with dye, her ledger open on the counter. She's married, you can see the ring, but she's conducting business independently, signing contracts in her own name, maintaining separate accounts from her husband, who works as a goldsmith 3 streets away. Welcome to the strange, liberating world of urban merchant wives, where coverture's iron rules bent just enough to let commerce breathe. Medieval towns operated under different legal principles than the countryside manors you know. Cities wanted trade, wanted bustling markets and skilled artisans and the tax revenue all that commerce generated. But coverture created problems for commercial families. If a merchant's wife couldn't sign contracts independently, couldn't be sued for business debts, couldn't collect payments owed to her, how could she help run the family business while her husband travelled for weeks acquiring stock? How could she manage the shop when he fell ill? The answer emerged through municipal custom and guild regulations, the legal fiction of the feme sole trader, a married woman who, for commercial purposes only, could act as if she were unmarried, a legal person in her own right. The term feme sole literally meant woman alone, and it described unmarried women or widows who operated with full legal capacity. A feme sole trader, or feme sole merchant, was a married woman granted that same capacity specifically for her business activities. The rules varied by city. London's customs differed from York's, which differed from Paris's or Bruges's, but the pattern was consistent. If a married woman practiced a trade independently from her husband, she could be recognised as a feme sole for those transactions. She could contract debts in her own name, sue customers who didn't pay, be sued by suppliers she owed money to, and maintain accounts separate from her husband's finances. It was a carve-out from coverture, a pragmatic exception that acknowledged economic reality mattered more than legal consistency. Agnes explains her situation as she measures out wool for you. Her husband is a goldsmith. She's a cloth dyer, completely separate trades, separate customer bases, separate finances. The city recognises her as a feme sole merchant, which means if she extends credit to a customer who never pays, she can sue that customer herself. If she fails to pay her suppliers and they sue her, the judgment affects her business property, not her husband's goldsmithing tools. This separation protects both spouses. His business failures won't destroy her enterprise, and her debts won't seize his workshop. It's practical, elegant even, and it creates space for married women to participate in urban economies as genuine independent actors. But the system had limits and complications that historians still debate. First, feme sole status was never automatic for all married women. You couldn't just declare yourself a feme sole and start signing contracts. The city or guild had to recognise your status, often requiring you to register formally, pay fees, or demonstrate you were conducting business genuinely separate from your husband's control. Second, the independence was narrowly tailored to trade. Agnes could sue about business debts, but she still couldn't sell her house without her husband's consent, couldn't write a will disposing of her personal property, couldn't act independently in non-commercial matters. Coverture still governed her domestic life. Only her commercial identity escaped. Third, and this is where it gets interesting, husbands could sometimes be held liable for their feme sole wives' business debts anyway, depending on local customs and circumstances. If Agnes's cloth business collapsed owing large sums, creditors might still try to reach her husband's property, arguing that he benefited from her business or tacitly supported it. The legal boundaries weren't always clear, and court cases argued over where the husband's responsibility ended and the wife's independent liability began. Medieval judges had to navigate these ambiguous zones, sometimes creating precedents that expanded women's independence, sometimes contracting it. You meet other women operating in this peculiar space of partial independence. There's Marjorie the brewer, who runs a successful ale business from her home. Brewing was one of the few trades dominated by women in medieval towns. It required managing fermentation, knowing herb mixtures, and maintaining consistent quality, all skills that overlapped with household management. Marjorie brews, sells to local taverns, and keeps accounts her husband never examines. She's registered as a feme sole with the Brewers' Guild, pays her own guild fees, and appears in court when disputes arise about ale quality or unpaid tabs. Her husband works as a carpenter, and though they live in the same house, their financial lives run on parallel tracks. Then there's Joan the Silkwoman, part of London's luxury textile trade. Silkwomen were often wives or widows of wealthy merchants, women with enough capital to import expensive raw materials and enough skill to work them into finished goods. Joan explains that she inherited her silk trade knowledge from her mother, who learned from her mother, 3 generations of women passing down specialised expertise that existed almost entirely in female professional networks. Joan employs 2 apprentices, both young women learning the trade, and she negotiates contracts with noble women for custom silk work. When she signs these contracts, she signs Joan Baker Silkwoman, and the contracts hold in court because London recognises her feme sole status. Her husband, a prosperous grocer, operates his own business without interference or involvement in hers. One quirky historical detail: some medieval guilds were exclusively female or predominantly female. Silkwomen in London and Paris, linen workers in various cities, even some embroiderers' guilds maintained their own regulations, trained their own apprentices, and policed quality standards among members. These guilds gave women collective power and professional identity outside domestic roles. They also created networks where business knowledge, credit, and opportunity circulated among women, building economic communities that functioned semi-independently from the male-dominated guild system. Historians still argue about how much real power these female guilds wielded versus how much they were tolerated exceptions to male economic dominance, but the evidence suggests they were meaningful institutions that shaped urban economies. You're also learning that feme sole status created unusual situations around debt and liability. Imagine a married couple where both spouses are registered traders in separate businesses. The husband's business fails catastrophically, leaving him imprisoned for debt. Yes, medieval debtors could be jailed until they paid, or their creditors tired of maintaining them. His wife's business, protected by her feme sole status, continues operating. She can't pay his debts, legally they're separate, but she's also not dragged down by his failure. This separation could save families from total ruin, allowing one spouse's enterprise to survive and support the household while the others collapsed. It was a primitive form of bankruptcy protection, carved out through commercial custom rather than explicit legislation. The guild system also affected married women's work in complicated ways. If your husband was a master craftsman in a guild and died, you as his widow might be allowed to continue operating his workshop for a limited time, often a year or until you remarried. This was called the widow's privilege, and it acknowledged that you'd been working alongside him, knew the trade, and deserved a chance to maintain income. Some guilds were more generous, allowing widows to continue indefinitely, even train apprentices and maintain full master status. Others were restrictive, viewing widows as temporary placeholders who should remarry quickly or retire from the trade. The variation reflected ongoing tensions between economic pragmatism. Widows had skills and knowledge worth preserving, and guild protectionism. Fewer practitioners meant less competition and higher prices for those remaining. Agnes finishes weighing your wool and names her price. You negotiate, she expects it. Would be insulted if you didn't, and settle on terms. She'll deliver half now, half in a month when her next shipment arrives. You clasp hands to seal the agreement, and she makes a notation in her ledger. This transaction feels different from dealing with merchants in the countryside. Agnes isn't someone's wife helping with the family business. She's a merchant in her own right. Her authority acknowledged by the city. Her contracts enforceable in court. The encounter leaves you thoughtful as you navigate back through muddy streets toward home. That night you wonder what your life would have been like if you'd grown up in a town instead of the countryside. If you'd learned a trade. If you'd become a feme sole merchant with your own business and your own legal identity carved out from coverture's weight. It's an alternate version of life that existed for some medieval women. Not most, probably not even many, but enough that it represented a real possibility rather than pure fantasy. Urban commercial life created cracks in the legal system that subordinated women, and some women wedged themselves into those cracks and built something resembling independence. They didn't overturn the system. Coverture remained the default, and even femme-sold traders were only partially liberated. But they proved the system could bend, which meant it wasn't quite as natural or inevitable as authorities claimed. That knowledge alone was worth something, even if you'd never personally benefit from it. You're sitting in a drafty manor hall, reading a letter by candlelight. The parchment crackles between your fingers, the handwriting confident and angular. Cousin, it begins. Regarding the matter of the disputed boundary with Hayden, I have retained counsel and expect judgment by Michaelmas. The steward continues troublesome. Dismiss him if you see fit. Your affectionate cousin, Margaret Paston. You set the letter down carefully, marvelling at its tone, authoritative, strategic, utterly unsentimental. This isn't some flowery note about household recipes or prayers for someone's health. This is business correspondence, property management, legal manoeuvring, and it's written by a woman whose letters, along with those of her mother, sisters, and daughters, would survive 5 centuries to become one of the richest sources we have for understanding how medieval women actually navigated property, power, and the law. The Paston family of 15th century Norfolk, England, weren't royalty or even high nobility. They were ambitious gentry, lawyers and landowners clawing their way up the social ladder. What makes them invaluable to historians is their obsessive letter writing and extraordinary luck. Over 1,000 letters survived, creating an intimate window into medieval life. And women's voices fill those letters. Margaret Paston, the matriarch, wrote constantly to her husband John when he was in London attending to legal matters. She managed estates, negotiated with tenants, supervised building projects, gathered intelligence on rivals, and defended property from armed attacks. Yes, armed attacks. Because this was the era of regional power struggles and weak royal authority. Her letters reveal a medieval woman functioning as a state manager, legal strategist, and sometimes quasi-military commander, all while technically operating under coverture. Margaret's letters are astonishingly direct. In one, she informs her husband that a rival family attempted to seize one of their properties by force. I had word that certain of Hayden's men would come to Gresham and break in and take possession. I sent my servants to keep the place. She dispatched armed men to defend the manor, essentially commanding a small private force. In another letter, she discusses tenant management. Right worshipful husband, I recommend me to you, praying you to know that I've received your letter. As for John Chapman's rent, he says he will pay when the king's money comes. She's tracking payments, making judgment calls about which tenants to pressure and which to grant extensions. These aren't the letters of a legally invisible person. These are the letters of someone running a complex operation with full practical authority. But here's the paradox that makes the Paston letters so revealing. Margaret almost never owned this property legally. It belonged to her husband John, and after his death, to their sons. Her authority was delegated, informal, based on practical necessity and her husband's trust rather than legal right. Yet that delegated authority was real and extensive. When John was away, which was frequently for months at a time, Margaret acted as his proxy in everything except the most formal legal transactions. She hired and fired servants, settled local disputes, negotiated with neighbours, managed agricultural cycles, and represented the family and the community. Medieval wives of property-holding men often functioned this way, legally powerless, practically essential. The letters also reveal the tensions this arrangement created. Margaret sometimes chafes at her lack of formal authority when legal matters require her husband's seal or signature. She must wait for his return or send documents to London for his approval, creating delays that endangered the family's interests. She writes with barely concealed frustration about missed opportunities and problems that festered while waiting for her husband's legal imprimatur. Yet she never directly challenges the system, she works within it, finding ways to act effectively despite its constraints. Her letters show a mind constantly calculating how to achieve goals while navigating legal limitations. Do you remember how coverture supposedly erased married women's legal existence? The Paston letters complicate that story beautifully. Yes, Margaret couldn't sell family land or sign binding contracts in her own name, but she negotiated marriage alliances for her children, gathering information about potential spouses' wealth and character, conducting what amounted to due diligence investigations. She supervised complex building projects, writing detailed instructions about construction specifications. She gathered political intelligence, maintaining networks of informants who reported on rival families' activities. She was in everything but legal title, running a significant enterprise. Historians still argue about how to characterize this reality. Was Margaret exceptional, or was she typical of women in her social class? The answer seems to be exceptional in the evidence she left, typical in the functions she performed. Agnes Paston, Margaret's mother-in-law, appears in the letters too, offering another generation's perspective. Agnes was widowed and therefore legally independent, holding her dower rights to various properties. Her letters show a woman jealously guarding her authority against encroachment by her sons. When Margaret and John moved into one of Agnes's properties, tension erupted. Agnes wrote stinging letters asserting her rights as dower holder and demanding respect for her authority over the property. The clash between widows' rights and the heirs' expectations plays out in real time through their correspondence. Agnes ultimately banned Margaret and John from certain properties, asserting her dower rights with the full force of law behind her. It's a remarkable glimpse of how widowhood transformed power dynamics within families. The younger generation of Paston women appear in letters discussing their marriage prospects, and their voices reveal medieval women negotiating or resisting the marriage market. Marjorie Paston fell in love with the family's bailiff, a man far beneath her social station, and secretly married him. The family was outraged. Her mother Margaret refused to see her. The Bishop of Norwich was brought in to investigate whether the marriage was legally valid. Marjorie stood before the bishop and insisted, against intense family pressure, that she had freely consented to the marriage and considered herself validly wed. The bishop, after examination, agreed. Marjorie's determination and her willingness to sacrifice family wealth and status for her choice comes through the letters with startling clarity. Here was a medieval woman using the law's requirement of free consent to defy her family's wishes, claiming agency in the one moment when law granted her any, the moment of marrying. One quirky detail from the Paston letters: they frequently mention sending tokens and small gifts with messages, a gold ring, a piece of fabric, a devotional book. These objects carried meaning beyond their material value, serving as proof the letter was genuine and reinforcing emotional bonds across distance. Margaret sends her husband reminders of their connection. He sends her tokens of affection and status markers she can display to maintain the family's reputation locally. The letters and objects together formed a communication system that kept geographically separated family members functioning as a coordinated unit. Medieval people understood that power required both formal authority and informal influence, both legal documents and personal relationships. The Paston correspondence also reveals how information networks functioned. Margaret writes constantly about what she's heard from various sources, Servants report on neighbours' activities. Travelling merchants bring news from London. Cousins visiting from other counties share gossip that's actually valuable intelligence about property disputes, marriages and political alliances. Medieval women, especially those managing estates, needed to be skilled intelligence gatherers without telephones or newspapers. Information moved through personal networks and women's networks, running through marriages, kinship ties and household connections, carried vital knowledge about everything from crop prices to which judge was corrupt to which family was financially overextended and vulnerable to property acquisition. Reading these letters centuries later, you can almost hear Margaret's voice. Sharp, practical, occasionally tender, always calculating the angles, she lived within a legal system that classified her as her husband's subordinate. Yet she commanded resources, made decisions affecting hundreds of people, and shaped her family's fortune through intelligence and determination. The gap between legal theory and lived reality yawns wide in the Paston letters. They remind you that law tells only part of the story, that behind every legal doctrine about women's incapacity and subordination, real women were negotiating, managing, strategizing, and occasionally fighting with whatever tools their circumstances provided. Tonight, as you set aside your own correspondence, less voluminous than the Paston's collection but still a record of your negotiations and decisions, you think about future readers. Will anyone centuries from now discover your letters and recognize in them a life more complex than legal categories suggested? Will they see past the formal language about your husband's property and your widow's dower to understand that you were a person making choices, wielding what power you could grasp, living a full and complicated life despite what the law said about women's legal invisibility? The Paston women left that gift to history. Proof that medieval women existed not just as legal categories, but as thinking, feeling, strategizing human beings who refused to be fully defined by the laws that constrained them. You're seated in a lawyer's office that smells of parchment and sealing wax, listening to him explain a new arrangement he's calling jointure. He speaks with the enthusiasm lawyers reserve for clever innovations, and you're trying to follow his logic even as unease creeps through your chest. Instead of relying on dower, he says, tapping the document before him, your family and your future husband's family can agree to specific properties you'll receive upon his death. Fixed, certain, named in advance, much cleaner than waiting for dower assessments and disputes with heirs. He smiles encouragingly. You do not smile back. Something about this feels like a trap disguised as improvement, and your instincts, honed by years of watching legal manoeuvring, are screaming caution. This is the late 15th century now, and you're witnessing a legal innovation that will gradually replace the ancient dower system and, in the process, make many widows worse off despite lawyers' assurances about clarity and certainty. Jointure emerged as English law grew more sophisticated, and property-owning families sought more control over inheritance planning. The traditional dower, automatic 1/3 of all lands the husband held during marriage, was inflexible. Families couldn't plan around it precisely, couldn't protect certain properties from being divided, couldn't structure inheritance to keep estates intact. Jointure solved these problems by making widows' provisions negotiable and contractual rather than automatic. And there's the danger. What's negotiable can be negotiated down. Here's how jointure worked. During marriage negotiations, before the wedding, the two families would agree that instead of the bride receiving traditional dower rights, she'd receive a jointure, specific properties or annual income designated in the marriage settlement. These properties were often held jointly by husband and wife during the marriage, hence jointure, meaning a joint holding. And upon the husband's death, the wife would continue holding them for a lifetime. The advantage, lawyers explained, was certainty. The widow knew exactly what she'd receive, and the heir knew exactly what properties would return to him eventually. No waiting for assessors, no boundary disputes, no arguments about which third was fairly valued. But historians still argue about whether jointure genuinely improved widows' situations or represented a systematic reduction of their rights. The optimistic view holds that jointure allowed families to tailor provisions to circumstances, perhaps giving the wife better quality lands than she'd get in a random third, or ensuring she received properties near her birth family where she had support networks. The cynical view notes that jointure negotiations happened between the bride's father and the groom's father, with the bride herself having little voice, and that families increasingly used jointure to reduce the total value transferred to widows while maintaining appearances of generosity. When dower was automatic, widows got 1/3 regardless of anyone's wishes. When jointure was negotiated, widows got whatever the families agreed upon, which might be less than 1/3 or might be properties of inferior value. You're hearing about cases where this played out badly. A noblewoman you know accepted a jointure of 2 manors that seemed substantial during marriage negotiations, but her husband inherited additional lands after the wedding, lands not covered by the jointure agreement. When he died, she received only the 2 original manors, not 1/3 of his expanded estate. Under traditional dower law, she would have been entitled to 1/3 of everything he held during the marriage, including later acquisitions. Under jointure, she received only what the contract specified. She was trapped by the very certainty the lawyers had praised, certain to receive less than the older system would have provided. The legal mechanism that made jointure possible was called barring dower. A woman could be induced to formally give up her automatic dower rights in exchange for the negotiated jointure settlement. This required her consent. Theoretically, courts would examine her privately to ensure she understood what she was surrendering and agreed voluntarily. But do you remember the problems with these private examinations? Pressure from family, limited understanding of complex property law, social expectations that women defer to male relatives' judgment. All these factors could turn voluntary consent into something closer to coerced acceptance. Young brides, particularly, often lack the knowledge or confidence to resist when fathers and future husbands assured them the jointure was generous and fair. One quirky legal development: some women started insisting on clauses that preserved dower as a backup. Their marriage settlements would specify the jointure, but include language like, if the jointure lands prove insufficient, the widow may also claim traditional dower. These hybrid arrangements tried to get the best of both systems, the certainty of jointure with the security of dower as a fallback. Lawyers hated these clauses because they reintroduced the uncertainty jointure was meant to eliminate, but some shrewd families insisted on them, recognizing that flexibility favoured widows while rigid contracts favoured heirs. The existence of these hybrid arrangements suggests that at least some medieval families understood jointure could disadvantage women and sought to protect their daughters and sisters. The shift from dower to jointure also reflected changing attitudes about inheritance and family continuity. Medieval landowners increasingly viewed their estates as indivisible units that should pass intact from generation to generation. Dower's requirement to carve out 1/3 for the widow's lifetime disrupted this vision, fragmenting the estate and reducing the heir's ability to manage it as a unified whole. Jointure allowed families to segregate certain properties specifically for the widow's support, while keeping the core estate unified under the heir's control. This served the family's long-term interests, maintaining power and status across generations, but it served these interests by constraining how much property widows could claim. The widow's needs became subordinate to the dynasty's needs, a shift that's subtle but profound. You're also discovering that jointure created new opportunities for widows to be cheated through legal technicalities. If the jointure specified certain annual income but didn't account for inflation or economic changes, A widow might find her generous settlement barely covering expenses 20 years later. If the jointure gave her specific properties, but those properties declined in value or productivity, she had no recourse to claim better lands. Traditional dower, being a fraction of the estate rather than specific parcels, adjusted automatically if the overall estate prospered. The widow's third prospered proportionally. Jointure fixed the widow's portion in place. Better for estate planning, but potentially disastrous for the widow if circumstances changed. The church initially resisted jointure, viewing it as an attempt to circumvent dower rights that canon law strongly protected. Church courts preferred traditional dower and were sceptical of arrangements that seemed designed to minimise widows' inheritances. But by the early 16th century, even church courts were accepting jointure as valid if properly negotiated and consented to. The shift reflects law's gradual evolution from protective customs toward contractual flexibility, from widows are entitled to this by ancient right, toward parties can agree to whatever terms they negotiate. That evolution privileged freedom of contract over protection of vulnerable parties, a pattern that would accelerate in later centuries. You decide against jointure for yourself. When the lawyer presses, explaining the advantages, you hold firm. I'll take my chances with traditional dower, thank you. He looks disappointed. Jointure settlements generated fees for lawyers, and your refusal costs him business. But he notes your choice in his records. You're fortunate to have this choice at all. Many women, particularly younger or less educated ones, were guided into jointure arrangements without fully understanding what they were surrendering. You've lived long enough, navigated enough legal situations, to recognise when modern improvements actually benefit the people promoting them more than the people subjected to them. That night, you think about all the widows who'll come after you, decades and centuries hence. Will they even know traditional dower existed? Will jointure become so standard that the oldest, potentially more generous system is forgotten entirely? Legal changes don't just affect property distribution, they reshape memory. Erasing alternatives until the current system seems natural and inevitable. Fighting for traditional dower isn't just about your personal financial security, it's about preserving options for women who'll follow. Keeping alive the knowledge that law wasn't always structured this particular way and needn't remain so forever. Every widow who insists on dower rather than accepting jointure is conducting a quiet rebellion, refusing to let ancient protections be negotiated away in the name of progress and efficiency. You're standing at the gates of a Benedictine abbey, watching an abbess stride across the courtyard with an authority that makes bishops nervous. She's draped in fine black wool, a silver cross hanging against her chest, and she's issuing orders to a steward about timber sales and mill repairs with the confidence of someone who controls more land than most barons. Behind these walls, something paradoxical flourishes. Religious women who've renounced worldly power manage vast earthly estates, negotiate with kings, and wield economic influence that would be impossible for their secular sisters. Welcome to the medieval nunnery, where vows of poverty somehow coexisted with balance sheets that would make merchants weep with envy. Large monasteries and convents were among the wealthiest institutions in medieval Europe. Their treasuries swollen by centuries of donations from nobles seeking spiritual insurance. When a lord died, he might bequeath entire manors to a religious house, hoping the monks or nuns would pray for his soul through eternity. When wealthy widows took religious vows, they brought their property with them, not personally, since they'd renounced ownership, but as donations to the institution. Over generations, these gifts accumulated into massive portfolios. The Abbey of Fontevraud in France controlled dozens of priories and hundreds of dependent farms. Shaftesbury Abbey in England was among the realm's richest landholders, its abbess summoned to Parliament alongside male lords. These weren't quiet prayer retreats, they were economic powerhouses, and the women who ran them were property managers, political operators, and legal strategists operating at the highest levels. The abbess you're watching commands an estate that includes farmland, forests, fisheries, mills, and entire villages. She collects rents from hundreds of tenants, some of whom have never met her but know her authority through her bailiffs and stewards. She appoints priests to parish churches on abbey lands, a spiritual power that also carries temporal influence since those priests answer to her. She holds courts where her tenants' disputes are judged, not by her personally, but by officials acting in her name and under her ultimate authority. She negotiates with merchants about wool sales, with nobles about boundary disputes, with royal officials about taxes. She's doing everything a secular male lord would do, exercising powers that would be unthinkable for a married woman or even most widows. The paradox gets delicious when you examine it closely. These women achieved this power by renouncing marriage, family, and personal property, by removing themselves from the secular marriage market. They escaped coverture's grip. As brides of Christ rather than earthly husbands, they needed no man's permission to sign contracts or manage property. The legal fiction of corporate religious identity, the abbey as a perpetual legal person, gave them an institutional platform to exercise authority without triggering the usual objections about women's unfitness for power. Historians still argue whether this represents genuine female empowerment or just an exception that proves the rule of male dominance. After all, these women could only wield power by declaring they weren't really participants in the normal gendered world. They were spiritual beings, set apart, not threatening the social order but existing in a separate category altogether. The daily reality was more complex than either celebration or dismissal captures. Yes, the abbess controlled vast wealth, but she also answered to male ecclesiastical authorities, bishops who could visit the abbey, inspect accounts, and theoretically override her decisions. Yes, she appointed stewards and bailiffs, but those officials were almost always men, since women travelling the countryside collecting rents would face dangers and social disapproval. The abbess wielded power, but through male intermediaries and within structures ultimately controlled by the male church hierarchy. She was powerful and subordinate simultaneously, a duality that medieval religious women navigated with varying degrees of skill and frustration. You meet a nun visiting from a smaller priory, and she explains the financial realities with weary pragmatism. Her house struggles constantly. Too few nuns to justify its landholdings, too little income to maintain buildings properly, caught between demands from the mother abbey and pressure from local nobles who covet the priory's properties. She spends half her time dealing with legal disputes, a neighbour who moved boundary markers, a tenant who refuses to pay rent claiming the priory's title is defective, a local lord who simply seized a meadow and dares them to fight him in court. We pray, yes, she says, but we also spend hours with lawyers, arguing about land we supposedly renounced. The tension between spiritual ideals and economic necessities runs through every aspect of conventual life. One quirky historical reality: some nunneries accepted wealthy women as pensioners rather than full nuns. These women lived within the convent, participated in religious life to varying degrees, but maintained control over their personal property and could leave if they wished. For widows who wanted security without fully committing to religious life, this arrangement offered shelter, respectable occupation, and an escape from family pressure to remarry. The convents benefited too. Pensioners paid for their lodging and often left bequests when they died. It was a medieval retirement home for women, blending spiritual and economic functions in typically medieval fashion. Neither purely religious nor purely mercenary, but pragmatically both. The political power some abbesses wielded was extraordinary. Eleanor of Aquitaine, before and between her roles as queen, spent time in Fontevraud Abbey, and the abbess there was among her trusted advisers. Hildegard of Bingen, though famous for her mystical visions and theological writings, also ran the Abbey of Rupertsberg with formidable administrative skill, defending its property rights against the Archbishop of Mainz himself. These women corresponded with popes and emperors, offering spiritual counsel that carried weight precisely because they had renounced earthly ambition, or at least appeared to have done so. The renunciation of worldly power, paradoxically, could become a source of moral authority that translated back into worldly influence. The contrast with secular women's property rights is stark and instructive. A married noblewoman might come from a family wealthier than most abbeys, yet she personally controlled almost nothing. The abbess of a modest convent, ruling a fraction of that wealth, controlled it absolutely within her sphere. The difference wasn't economic scale, but legal capacity. Religious life gave women institutional authority that secular life systematically denied them. This is why some historians view convents as spaces of female autonomy and power, while others see them as safety valves that contained women's potential for disrupting secular gender hierarchies by allowing exceptional women an outlet that didn't threaten the broader system of male dominance. You're also hearing about resistance and tension within convents. Not every nun accepted the abbess's authority cheerfully. Disputes over finances, leadership, and daily regulations sometimes escalated into full rebellions, with nuns appealing to bishops or even the Pope over their abbess's head. These conflicts reveal that women's communities weren't automatically harmonious just because they were single-sex. Power dynamics, personality clashes, and competing visions of religious life created friction. Some of the most bitter property disputes involved nuns arguing among themselves about how conventual resources should be managed, strict poverty versus moderate comfort, investment in buildings versus charitable giving, accepting wealthy pensioners versus maintaining enclosed contemplative life. The Reformation would eventually devastate many of these female religious houses, dissolving them and seizing their properties. The abbesses and nuns would be scattered, their economic power broken, their institutional platforms destroyed. But you're living before that catastrophe, in an era when convents represented genuine, if constrained, centres of female authority. The abbess you're watching supervises workers repairing the chapter house, her voice cutting clearly across the courtyard as she corrects some detail of the construction. She's never married, never had children, renounced personal wealth, and yet she's more powerful than almost any secular woman in the kingdom. Her authority acknowledged by law, backed by the church, and exercised daily over considerable resources and many people's lives. It's a strange bargain, freedom through renunciation, but for some medieval women, it was the best bargain available, and they seized it with both hands. You're sitting in a garden courtyard in Toledo, Spain, listening to a Jewish woman named Rachel describe her property arrangements, and your mind reels with the differences from everything you've learned about English common law. Rachel owns a house, genuinely owns it, in her own name. Though she's married, her husband, a physician, owned separate property. When her father died, she inherited equally alongside her brothers, receiving a share of his estate that would have been unthinkable for a Christian daughter in your homeland. My ketubah protects me, she explains, showing you the marriage contract written in Hebrew. My husband owes me this amount if he divorces me or dies. It's not negotiable. It's required by Jewish law. Welcome to the parallel legal universes that existed within medieval Europe, where Jewish and Muslim women sometimes operated under property rules that gave them rights their Christian neighbours couldn't imagine. Medieval Europe wasn't legally uniform, and that's putting it mildly. Canon law governed Christian marriages, but Jews and Muslims living in Christian kingdoms maintained their own legal systems for internal community matters, including marriage and inheritance. Islamic law and Jewish law developed independent of Christian traditions, with different assumptions about women, property, and family obligations. The result was a patchwork where a Jewish woman in Barcelona might control property in ways a Christian woman in the same city couldn't, or where a Muslim woman in Sicily held inheritance rights exceeding those of her Christian neighbours. These parallel systems occasionally intersected, creating fascinating legal complications and revealing just how contingent and constructed, rather than natural or inevitable, any given property system was. Jewish law, derived from the Talmud and centuries of rabbinical interpretation, required the ketubah, a marriage contract specifying the husband's financial obligations to his wife. The ketubah amount was essentially a guaranteed debt the husband owed his wife, payable if he divorced her or upon his death. It functioned somewhat like dower, but with crucial differences. It was negotiated and specified in advance. It was portable, not tied to specific properties, and it gave the wife a secured creditor's position against her husband's estate. If he died owing debts, her ketubah claim had priority over many other creditors. This protection wasn't based on romantic notions about cherishing wives. It was practical recognition that divorce was legally available in Jewish tradition, and divorced women needed financial protection. Rachel explains further. Under Jewish law, she could own property separately from her husband, including property she brought to the marriage and property she acquired afterward through inheritance or gift. Her husband managed certain types of her property during marriage and enjoyed its income, but he couldn't sell it without her consent. If she inherited from her father, that inheritance remained distinctly hers, traceable and separable from marital property. This concept, separate marital property, was almost incomprehensible under English coverture, where marriage merged the wife's legal identity and property into the husband's. Jewish married women weren't legally invisible. They were recognized as distinct persons capable of owning property, though still operating under patriarchal restrictions about how they could deploy that property. Historians still argue about how much Jewish women's theoretical legal rights translated into practical autonomy, particularly given the overlay of Christian political authority and the vulnerable position of Jewish communities within Christian kingdoms. Having rights under Jewish law mattered only insofar as the Christian ruling powers permitted Jewish courts to enforce those rights. When conflicts arose between Christian and Jewish parties, Christian courts held ultimate authority, and those courts didn't necessarily respect Jewish women's property claims. A Jewish woman might own property under Jewish law, but find a Christian creditor seizing it through Christian courts that didn't recognize her separate ownership. The parallel legal systems existed in tension, sometimes harmoniously, sometimes explosively. Islamic law, governing Muslim communities in medieval Spain, Sicily, and other regions of Christian Europe with Muslim populations, provided yet another model. Under Islamic law, daughters inherited from their fathers, though typically half what sons received, reflecting patriarchal assumptions about men's greater financial responsibilities. Muslim women retained ownership of their dower, mahr, and any property they brought to marriage or inherited. The mahr was money or property the husband gave the wife at marriage, belonging to her personally. It wasn't held jointly or managed by the husband. It was hers to control, invest, or spend as she wished. Wealthy Muslim women sometimes used their mahr to finance business ventures or charitable foundations, operating as economic actors in ways Christian married women could only dream of achieving. You meet Fatima, a Muslim woman whose family remained in Christian-controlled Valencia after the Reconquista. She describes how her grandmother managed rental properties she owned, collecting rents and negotiating leases without male interference. My grandfather had his properties, grandmother had hers, Fatima says. They lived together, supported each other, but their finances were separate. This separation created a different marital dynamic than you know. Christian marriage imagined the couple as one economic unit with the husband as head. Islamic marriage, at least in its property dimensions, imagined two individuals with separate estates who'd formed a domestic partnership but retained distinct financial identities. Neither system was obviously more just, both reflected and reinforced gender hierarchies, but they distributed power and vulnerability differently. One quirky detail: Muslim women could include stipulations in their marriage contracts giving them unilateral right to divorce under certain conditions. If the husband took a second wife, if he moved her away from her family, if he failed to provide adequate support, these triggers could activate her right to divorce and reclaim her mahr. This contractual flexibility gave women leverage, though whether they could actually exercise it depended on family support, community pressure, and the husband's willingness to comply. Contracts were only as good as enforcement mechanisms, and women's ability to enforce contractual rights against resisting husbands was always uncertain. Regardless of what the law technically permitted, the differences between these systems sparked theological and legal debates. Christian writers sometimes pointed to Christian women's dower rights as evidence of Christianity's superiority, while conveniently ignoring coverture's erasure of married women's legal identity. Muslim and Jewish writers sometimes criticized Christian marriage law's harsh treatment of divorced women, while downplaying their own system's patriarchal restrictions. Everyone claimed their tradition protected women better than the alternatives, and everyone was partly right and partly self-serving. What's fascinating isn't determining which system was best. They all subordinated women in various ways, but recognizing that multiple approaches existed simultaneously, proving that no single arrangement was inevitable or natural. These parallel legal systems also created opportunities for strategic conversions and forum shopping. A Jewish woman facing a property dispute might convert to Christianity if she thought Christian courts would rule more favourably, though conversion brought its own complications and community ostracism. A Christian woman marrying a Jewish or Muslim man entered a different legal regime, gaining some rights while losing others. The boundaries between communities were porous enough that people could sometimes navigate strategically among legal systems, though such navigation carried enormous social, religious, and personal costs. You're struck by how much of what you've assumed was simply law or the way things are was actually just one cultural tradition's answer to universal questions about property, marriage, and power. English coverture wasn't the only possible system. It wasn't even the only system operating in medieval Europe. Women's property rights varied dramatically based on religion, region, and local custom. A Jewish woman in Provence, a Muslim woman in Granada, a Christian woman in London, and a Christian woman operating under Roman law in Italy all lived under different rules. Their options and constraints shaped by accidents of birth and faith, rather than any natural order. This realization is simultaneously liberating and frustrating. Liberating because it proves change is possible. Frustrating because it reveals how arbitrary and contingent your own constraints are. Tonight, as you reflect on these conversations, you feel the weight of paths not taken. If you'd been born into Rachel's community, you'd have had a ketubah protecting you. If you'd been born into Fatima's, you'd have owned your marriage gift outright. But you were born into a system that erased married women's legal existence and promised them 1/3 of their husband's estate if they outlived him. You can't change the system you inherited. But knowing alternatives existed, knowing other medieval women lived under different rules, makes your own system seem less like divine inevitability and more like human construction, capable of being reconstructed differently if enough people pushed hard enough. That knowledge is dangerous and precious, and you hold it carefully as you fall asleep, dreaming of parallel worlds where law was written differently. You're standing in a widow's receiving room, watching a suitor present his case with practiced charm. He's younger than you by a decade, his doublet expensive, his manner calculated to suggest both respect and romantic interest. A woman of your wisdom and property should not face these burdens alone, he says smoothly, gesturing vaguely toward the account books on your table. With a husband to manage such tedious affairs, you could enjoy the comfort you deserve. You smile politely, but your mind is performing rapid calculations that have nothing to do with romance and everything to do with survival. This man sees your widow's independence as an opportunity. For him, you see remarriage as a potential catastrophe that would erase everything you've spent years building. Welcome to the high-stakes chess game of widow remarriage, where love is optional but property transfer is inevitable. Medieval society viewed wealthy widows with profound ambivalence. On one hand, they were pitiable creatures who'd lost their protectors and deserved community support. On the other hand, they were dangerous anomalies, women with property and no husband to control them, operating independently in a world organized around male authority. This ambivalence manifested in intense pressure to remarry. Families wanted widows remarried to bring their property back under male management and to create new alliance opportunities. Communities wanted widows remarried to restore proper household structure. The widows themselves sometimes wanted to remarry for companionship, protection, or escape from loneliness. But remarriage came with brutal costs that many widows understood better than the men pressuring them. Here's the fundamental problem. If you remarry, coverture snaps back into place like a trap. Your dower property, which you control absolutely as a widow, becomes your new husband's to manage. He collects the rents, makes the decisions, and handles all legal matters. You revert to legal invisibility, and this time you're older, possibly with children from your first marriage whose inheritance interests conflict with your new husband's. The property you fought to claim, the independence you've learned to wield, the hard-won legal personhood, all of it evaporates the moment you speak new marriage vows. You become a feme covert again, covered by a different man's legal identity, your property subsumed into his estate. Medieval law tried to address these concerns through marriage settlements that protected the widow's existing property. Your lawyers could negotiate that your dower from your first marriage remains separate, that your new husband can't sell or mortgage it, that it passes to your children from the first marriage rather than your new husband's heirs. These settlements grew increasingly complex as lawyers tried to build walls around the widow's property, keeping it legally distinct despite the general rule that marriage merged spouses' property. But settlements were only as good as their enforcement, and enforcement required vigilance, legal knowledge, and resources to fight breaches in court. Many remarrying widows lacked these tools and watched helplessly as new husbands managed their property into different hands. There were also darker possibilities. A widow with substantial property was vulnerable to coercion, both subtle and overt. That charming suitor might become less charming and more insistent. Families might apply relentless pressure, arguing that a woman alone was vulnerable, that she needed a man's protection, that refusing remarriage was selfish or even sinful. In extreme cases, widows were kidnapped and forcibly married, yes, genuinely abducted, rushed through a ceremony while protesting, then considered legally wed despite their resistance. Canon law required the woman's free consent for valid marriage, but proving coercion after the fact was difficult, especially if the woman's own family had conspired in the abduction. Historians still argue about how common forced widow marriages were, but the existence of laws addressing the problem suggests it happened with disturbing regularity. One quirky medieval practice. Some widows made public vows of chastity, declaring before church officials their intention never to remarry. This wasn't taking full religious vows, they didn't become nuns, but it was a formal, witness commitment that gave them social and legal protection against remarriage pressure. A widow who'd vowed chastity could cite that vow when deflecting suitors, and community opinion generally supported such women as particularly virtuous. The vow also potentially complicated any future forced marriage, since marrying after a public chastity vow might be challenged as invalid. It was a defensive legal maneuver disguised as piety, and many widows used it skillfully. You're hearing stories that confirm your worst fears about remarriage. A widow you knew remarried a man who seemed respectable, even kind, during courtship, within a year of the wedding. He'd sold properties from her first husband's estate, despite settlements supposedly protecting them. He argued the sales were necessary to cover debts, his debts, incurred before the marriage, but now her problem because coverture made them jointly liable. Her children from the first marriage watched their inheritance vanish into their stepfather's creditors' pockets, and the widow had no legal recourse. She'd signed the marriage settlement trusting it would protect her children. She learned too late that trust was foolish, that legal documents required constant vigilant enforcement, and that her new husband's control over her property was nearly absolute once they married. Another widow remarried after pressure from her adult son, who wanted his mother settled and her property's future clarified. The new husband moved into the Dower property and immediately began treating the widow's son as an interloper. Tensions escalated until the son was effectively banished from his late father's estate, now controlled by a stepfather with no biological or emotional connection to him, but complete legal authority over the property during the widow's lifetime. The widow regretted the remarriage bitterly, but couldn't undo it. Divorce was nearly impossible under medieval canon law. She'd made her choice, and she'd live with its consequences until death released her or her new husband. Economic incentives complicated the picture further. A poor widow might desperately need remarriage for financial survival, especially if her first husband's estate was modest and her dower insufficient. Remarriage to a prosperous man could dramatically improve her material circumstances, even if it cost her legal independence. For these women, the calculus was different. Trading autonomy for security might be a rational, even necessary, choice. But wealthy widows faced opposite pressures. They had comfortable circumstances and could afford independence, yet they attracted suitors precisely because of that wealth. The richer the widow, the more men circled, sensing opportunity. Royal and noble widows faced particularly intense remarriage pressure because their marriages had political implications. A wealthy widow's remarriage could shift regional power balances, create new alliances, threaten existing ones. Kings sometimes claimed the right to approve or arrange noble widows' remarriages, treating the widow's consent as a formality while using her property as a political chess piece. The widow might find herself ordered to marry a royal favourite. Her own preferences irrelevant. Some widows paid enormous sums to the king for permission to remain unmarried, essentially purchasing their independence. These payments, called fines for freedom to marry, appear regularly in medieval financial records, proof that widow independence was valuable enough that women would bankrupt themselves to preserve it. You've decided you won't remarry, a decision that brings relief and anxiety in equal measure. Relief because you're protecting your hard-won independence and your children's inheritance. Anxiety because you're vulnerable in ways a married woman isn't. No husband to represent you in legal matters. No male presence to deter aggressive neighbours or grasping relatives. No automatic household head to organise labour and defence. You're building alternative support networks, alliances with other widows, relationships with reliable stewards and lawyers, connections with your adult children who'll defend their own inheritance interests which align with yours. It's exhausting, this constant vigilance. But it's preferable to the alternative of remarriage and erasure. That charming suitor is still speaking, painting pictures of companionship and shared burdens. You interrupt him gently but firmly. I'm honoured by your attention, but I'm not seeking to remarry. His expression shifts, the charm cracking slightly to reveal frustration underneath. He makes one more attempt, suggesting you're being imprudent, that a woman alone faces dangers she doesn't understand. You smile again, this time with teeth. I understand quite well, you say. That's why I'm refusing. He leaves shortly after, and you return to your account books, your property records, your independence, precarious, exhausting, and utterly worth defending against every man who'd take it from you with promises of protection that look suspiciously like subjugation. You're standing in a drafty courtroom that smells of unwashed wool and anxiety, watching a widow present her case before a judge who looks profoundly bored. She's arguing that her late husband's heir has denied her access to her dower lands, and she's brought witnesses, documents, and a determination that radiates across the room despite her trembling hands. This is what defending your rights looks like in medieval courts, not abstract legal theory, but flesh and blood women standing before male judges, navigating arcane procedures, and fighting for property that law promised them but heirs resist surrendering. Welcome to the litigation battlefield where widows learn to become legal warriors or watch their dower rights dissolve into meaningless parchment promises. Medieval courts were not widow-friendly spaces by any modern understanding. They were male-dominated, conducted in Latin or French that many women didn't speak fluently, governed by procedures designed by and for male litigants. Women couldn't be lawyers. The profession was exclusively male, so widows needed to hire advocates to speak for them, adding expense to an already costly process. Court sessions happened irregularly, sometimes requiring litigants to travel long distances and wait days or weeks for their case to be heard. The entire system seemed calculated to discourage women from pursuing their rights, yet pursue them they did, in numbers that surprise modern historians examining court records. The widow you're watching is using a legal procedure called writ of dower, a standard mechanism for claiming dower rights that tenants or heirs wrongfully withheld. The writ commanded the defendant, in this case her stepson, to appear in court and explain why he denied her the dower she was entitled to. It sounds straightforward, but the devil lived in details. She had to prove she'd been legally married, that her husband had owned the disputed property during the marriage, that she hadn't waived her dower rights through some earlier agreement, and that she was claiming the correct 1/3 portion. Each element required evidence, witness testimony, written records if they existed, sometimes physical inspection of boundaries by court-appointed officials. Medieval litigation was document-heavy for the wealthy, testimony-dependent for everyone else, and universally expensive and time-consuming. Heirs resisted dower claims through various strategies, some more legitimate than others. The stepson in this case is arguing that his father never legally owned the disputed property, that it belonged to the grandfather and merely passed through the father's hands briefly. Insufficient to create dower rights, it's a technical argument that, if successful, would deny the widow a substantial portion of her expected dower. Historians still argue whether such technical defences represented good faith legal interpretation or cynical attempts to exploit complexity and women's limited legal knowledge to cheat widows. Court records suggest both happened, sometimes simultaneously. Heirs who genuinely believed in their position but were also happy to benefit from denying the widow resources. You watch the widow respond through her advocate, producing a land charter showing her late husband held the property for 7 years before his death, well within the marriage period and clearly sufficient to create dower rights. The judge examines the document, questions witnesses about its authenticity, and appears to be leaning toward the widow. But then the stepson's lawyer introduces a complication. The property was sold during the marriage, and the sale proceeded without the widow's separate examination and consent. If the sale was valid, the property left the husband's possession before his death, potentially eliminating the widow's dower claim to it. If the sale was invalid because she didn't properly consent, the property is still subject to her dower, but then the current owner, who bought in good faith, faces losing land he paid for. Medieval property law created these maddening tangles where protecting one person's rights meant violating another's, and judges had to navigate without clear precedents or comprehensive written codes. One quirky legal strategy widows used: when heirs delayed turning over dower property, widows could claim not just the property but also the rents and profits that accrued during the delay. This was called men profits, and it meant the longer the heir stalled, the more he'd owe when judgment finally came. The threat of accumulating manor profits incentivized some heirs to settle rather than litigate, making it a useful pressure tactic. Widows' lawyers would calculate exactly how much grain, rent income, and mill profits the widow had been denied, present those calculations to court, and demand payment. Suddenly the heir wasn't just fighting over future income but owing substantial back payments, making settlement more attractive than continued resistance. You're learning about other legal tools in the widow's arsenal. There were criminal penalties for forcibly excluding a widow from dower lands. It could be prosecuted as disseisin, wrongful dispossession, with fines and even imprisonment for persistent offenders. Some widows brought criminal charges alongside civil dower claims, using the threat of criminal penalties to pressure heirs into cooperation. The tactic worked best when the widow had powerful family connections or community support. Since criminal prosecutions required sheriff cooperation and could be derailed by official corruption or sympathy for the defendant, but it was another lever widows could pull, another way to make resistance costly for heirs tempted to simply ignore the law. The courtroom drama concludes with the judge ruling in the widow's favour she'll receive her dower, including 3 years of back rents the heir wrongfully collected. The stepson looks furious, the widow exhausted but triumphant. She's won, but the victory came at enormous cost: months of litigation, substantial legal fees, emotional strain, and now the permanent enmity of her late husband's son. Some widows would decide such victories weren't worth the cost and would accept less favourable settlements to avoid court battles. Others, like this woman, fought not just for themselves but to establish precedents, to prove that widows could and would defend their rights, to discourage future generations of heirs from assuming widows would surrender meekly. You're also hearing about cases where widows lost, where judges ruled against them on technical grounds, or simply favoured male heirs over widows whose claims seemed legally sound. Court records show both patterns: judges protecting widows' dower rights, and judges finding ways around those rights when powerful interests preferred different outcomes. The law on the books promised widows 1/3. The law in practice delivered whatever judges, court officials, and local power dynamics produced. This gap between written law and actual enforcement meant widows needed more than just legitimate claims. They needed legal knowledge, financial resources for lawyers, social connections to pressure officials, and sheer stubborn determination to persist through a system designed to frustrate them. Some widows became serial litigants, appearing in court records repeatedly across years or decades, fighting the same families over the same properties in endless cycles of claims and counterclaims. These women learned courtroom procedures intimately, became familiar to judges and court officials, and developed reputations as formidable opponents not to be underestimated. They were effectively practicing law without a license, mastering legal strategy through necessity when formal legal education was closed to them. Their persistence changed outcomes not just for themselves, but for other widows who benefited when judges established precedents in serial litigants' favour. The financial burden of litigation meant that only widows with some resources could defend their rights in court. Poor widows whose dower consisted of small plots or modest rents often couldn't afford lawyers and court fees, meaning their rights existed more in theory than practice. They might reach informal arrangements with heirs, accepting less than their legal entitlement to avoid litigation costs. Or they might simply be cheated, watching heirs take property the widows legally owned but couldn't afford to fight for. This class dimension meant property law's protections for widows were strongest for wealthy and middling women, weakest for the poor, a pattern that historians recognise as depressingly consistent across medieval legal systems. Tonight, as you review your own legal documents, you feel the weight of potential future battles. Your children are grown, and relationships are good now. But you know that upon your death, disputes could erupt over property boundaries, over what constituted dower lands versus what belonged outright to the estate, over back rents and property damage and 1,000 other potential conflicts. You're meticulously organising records, labelling boundaries, creating documentary evidence that will support your position when litigation becomes necessary. You're learning from other widows' court battles, understanding that your rights are only as strong as your ability to prove them before judges who'd prefer not to deal with complicated property disputes involving women. The law promises you dower. Reality demands you fight for every acre, every shilling of rent, every legal recognition that you're entitled to what's supposedly already yours. You're standing in a throne room hung with tapestries depicting ancient battles, watching a woman in mourning black negotiate with bishops and nobles as if she's done this all her life. She has. Eleanor of Aquitaine has been queen, duchess, regent, prisoner, and now, in her widowhood, she's become perhaps the most powerful woman in Christendom. Her son Richard is off crusading, and she governs England in his absence with an authority that makes male barons grumble but obey. This is widowhood at its apex, where the crown and the dower right combine to create something medieval political theory never quite planned for. A woman wielding sovereign power through the respectable channel of maternal duty and widows' rights. Welcome to the paradoxical world of royal widows, where grief and mourning clothes could become the costume for political dominance. Royal widowhood operated under the same basic legal principles as common widowhood, but magnified to kingdom-shaking proportions. When a king died, his widow received dower, typically substantial properties, entire towns sometimes. With their revenues, these queen's dower lands or queen's gold provided income that could fund a small army or extensive patronage networks. The widow queen wasn't governing by right of inheritance. Her son inherited the crown, but she governed through maternal influence. Dower-based wealth. And the respect or fear she'd accumulated during her husband's reign, it was power exercised sideways, through channels medieval society found more acceptable than direct female rule. But it was unmistakably real power nonetheless. Eleanor of Aquitaine's story illustrates the pattern perfectly. She was Duchess of Aquitaine in her own right, one of the wealthiest territories in France, before becoming Queen of France through her first marriage, then Queen of England through her second, when her second husband, Henry II, died. She was already in her 60s, and conventional wisdom said she should retire to a nunnery or quiet estate. Instead, she became the de facto ruler of England while Richard was absent, raising ransom money when he was captured, negotiating treaties, suppressing rebellions, and managing the kingdom with ruthless efficiency. Historians still argue whether Eleanor was unusually talented, or whether many medieval queens could have governed similarly if given opportunity. But her example proved that female rule, when wrapped in the acceptable packaging of widowed mother protecting her son's interests, could be remarkably effective. The role of Queen Mother gave widowed queens cover for political activity that would be scandalous in other women. A widow queen wasn't seeking power for herself. Perish the thought, she was merely protecting her son's inheritance, providing wise maternal counsel, managing household affairs that happened to include armies and tax collection and diplomatic negotiations. The fiction of selfless maternal service allowed queens to wield power while maintaining the appearance of proper feminine subordination. They weren't challenging male authority, they were supporting it through temporary stewardship. That the stewardship sometimes lasted decades and involved making every significant decision about governance was a detail everyone agreed to politely ignore. Blanche of Castile provides another example. When her husband, King Louis VIII of France, died in 1226, their son Louis IX was only 12 years old. Blanche became regent, ruling France for years until Louis came of age. And even after his majority, she continued exercising enormous influence. She personally led military campaigns against rebellious nobles, yes, rode with armies. Though she didn't fight personally, she negotiated treaties with England, managed the royal treasury, appointed bishops and officials, and generally demonstrated that queenship was a political office that didn't necessarily require a living king. When Louis went on crusade, Blanche governed again as regent, proving her first regency wasn't a fluke but a demonstration of consistent administrative capability. She was so successful that contemporaries called her the real King of France, though they said it with grudging respect rather than affection. One quirky aspect of queen dowagers, their marriages had often been arranged for political alliance. Yet many became devoted to protecting their husband's dynasty after his death. They'd spend decades advancing their children's interests, defending territories, and maintaining political networks their husbands built. This devotion wasn't pure sentiment, their own status. Wealth and power derived from their connection to the royal house, but it also transcended pure self-interest. These women became embodiments of dynastic continuity, living connections between past and present reigns, repositories of institutional knowledge that outlived the men who technically held power. Not all royal widows wielded power gracefully or benevolently. Some became notorious for grasping at control, for manipulating succession, for pursuing personal vendettas under cover of dynastic duty. Joan of Navarre, widow of England's King Henry IV, was accused of witchcraft, almost certainly a political attack by enemies who wanted her dower lands and influence neutralised. She spent years under house arrest, her property confiscated, her political connections severed. The charges were eventually dropped, but her story illustrates the vulnerability even royal widows faced. Immense power combined with precarious legitimacy, always dependent on male relatives' continued support or at least tolerance. Royal widows also faced pressure to remarry for political purposes, their personal preferences subordinate to diplomatic necessity. A young queen dowager with substantial dower lands and potential to bear more children was a valuable political asset. Her remarriage could cement alliances, extend influence into new territories, or neutralize threats from ambitious nobles who might try to claim her by force. Some widowed queens resisted remarriage fiercely, using every tool at their disposal, including taking religious vows to maintain their independence. Others remarried strategically, choosing husbands who bolstered their power rather than diminishing it. Catherine of Valois, widow of England's Henry V, secretly married a Welsh squire named Owen Tudor, preferring to control her own romantic life even if it meant marrying far beneath her station. The marriage eventually came to light, causing scandal, but by then she'd already borne several children, including the grandfather of the future Henry VII. Sometimes romantic choice and political calculation aligned, sometimes they conflicted spectacularly. The relationship between queen dowagers and their sons could be collaborative or contentious. Some sons valued their mother's experience and governed cooperatively with them. Others chafed at maternal influence and pushed their mothers aside as soon as possible. eager to establish their own authority without the shadow of a powerful widow mother. Historians still argue about whether medieval kings who cooperated with their dowager mothers were weak or wise, and whether dowager mothers who maintained influence were admirable or overreaching. The answer, frustratingly, varied by personality and circumstance. Some dowager-son partnerships were genuinely collaborative, others masked bitter power struggles. You think about these royal widows as you manage your own much humbler widow's portion. The scale is incomparably different. Eleanor governed kingdoms while you manage farms, but the fundamental dynamic is similar. Widowhood created space for female authority that marriage and daughterhood denied. Whether that space encompassed a nation or a modest estate, it represented the same legal transformation, from legal invisibility to recognized personhood, from subordination to autonomy, from being someone's wife to being yourself. The queens had more dramatic stories, commanded more resources, left larger marks on history, but they walked the same basic path every widow walked, from grief through legal transformation into a new identity defined by survival, autonomy, and the constant defense of rights that law promised but practice often contested. Tonight, reading chronicles about Eleanor's latest political maneuvers, she's arranging her granddaughter's marriage now. Weaving yet another alliance web, you feel connected across the vast social distance. She's a queen, you're a country widow, but you're both women who've learned to navigate widowhood's opportunities and dangers, who've discovered that the price of independence is eternal vigilance, and who've found that mourning black can be armour as much as it is remembrance. The crown may be different, but the widow's portion, whether measured in kingdoms or acres, operates by the same fundamental logic. 1/3 of what was his becomes yours. And then you spend the rest of your life defending it against everyone who thinks it should be theirs instead. You're sitting in a lawyer's office again. It seems you're always in lawyers' offices lately. And this one is explaining cheerfully how property law is evolving. We're moving toward more rational systems, he says, shuffling documents. Clearer rules about inheritance, better protection of estates from fragmentation. He doesn't say protection from widows, but you hear it anyway, in the spaces between his words. The air feels heavy with change, and not the good kind. You're witnessing the beginning of a long, slow erosion of women's property rights that will take centuries to fully unfold. But the direction is already clear. Medieval law's messy compromises that gave women some protection are being replaced by tidier systems that somehow always manage to consolidate more power in male hands. The late medieval period, stretching into the early modern era, saw intensifying efforts to rationalise property law and reduce what lawyers saw as inefficiencies. Dower was one of their prime targets. From the male heir's perspective, Dower created problems. It fragmented estates, tied up property for the widow's potentially long lifetime, introduced uncertainty into inheritance planning, and gave women control over resources that should flow directly from father to son. Legal reformers increasingly argued that jointure, negotiated settlements, was superior to automatic dower because it allowed families to plan rationally, protect estate integrity, and provide for widows without unnecessarily constraining heirs. The Statute of Uses passed in England in 1536 fundamentally altered how property could be transferred and controlled. While technically about trust arrangements and property transfers, its effects rippled through dower law in complex ways that historians still debate. The statute made it easier for property owners to create arrangements that bypassed widows' dower claims, essentially allowing men to will property away from the automatic 1/3 rule. Combined with a growing popularity of jointure agreements that replaced dower, the statute represented a significant shift in leverage from widows to property-owning men and their heirs. What had been an automatic, non-negotiable right was becoming something that could be contracted away. negotiated down or cleverly avoided through sophisticated legal instruments. You're watching this happen in real time through conversations with other widows whose daughters and granddaughters are making marriage settlements. The younger generation increasingly accepts jointure without fighting for traditional dower. Partly because their families pressure them. Everyone does it this way now. And partly because they don't understand what they're surrendering. The knowledge that dower was once automatic, once guaranteed, once non-negotiable is fading from collective memory. Within a generation or two, women won't even know to demand traditional dower because they'll never have heard of it as a real option. Legal change doesn't just alter rules, it erases alternatives from imagination, making the new arrangements seem natural and inevitable. The Protestant Reformation accelerated these changes by dissolving monasteries and convents across much of Europe. Remember those powerful abbesses managing vast estates? By the mid-16th century, most of them were gone, their lands seized by the crown and redistributed to male nobles and gentry. The destruction of female religious houses eliminated one of the few institutional spaces where women wielded significant economic and political power. Historians still argue about whether the Reformation improved or worsened women's overall position, but its effect on female property control was unambiguously negative. It destroyed institutions that had allowed women to exercise authority and replaced them with nothing comparable. The emerging ideology of companionate marriage also affected women's property rights in subtle ways. As marriages were increasingly described as partnerships based on affection and mutual respect rather than economic arrangements, the explicit bargaining over dower and marriage portions began to seem crass and mercenary. The new ideal suggested that wives should trust their husbands to provide fairly, that explicit property protections were unnecessary between loving partners, that worrying about widowhood during marriage negotiations revealed suspicious and unromantic calculation. This shift in rhetoric made it harder for women and their families to insist on protective property arrangements without appearing grasping or distrustful. Love and legal protection were framed as opposites rather than complements, and women who chose legal protection were painted as choosing against love. One quirky development. As formal legal protections weakened, informal protections through wills became more important. Husbands who wanted to provide generously for their widows could do so through detailed wills that left property in trust for the wife's use, sometimes with conditions that protected her against pressure to remarry. These testamentary provisions were individually negotiated and varied wildly in generosity, creating a patchwork where widows' outcomes depended heavily on their husbands' goodwill and foresight. Good husbands left careful provisions. Indifferent or hostile husbands left nothing beyond what law minimally required. The shift from automatic rights to testamentary gifts transferred power from widows, who'd held dower automatically, to husbands, who now controlled how much they'd provide through their wills. The concept of family settlements emerged among wealthy families, involving elaborate arrangements that planned inheritance across multiple generations. These settlements aimed to keep estates intact, directing property through the male line while providing for widows and daughters through carefully calibrated allocations that wouldn't wastefully fragment the estate. Women's shares in these arrangements were calculated to provide maintenance without threatening estate integrity, a balance that invariably favoured keeping the estate whole over maximising women's provisions. Historians see these settlements as early manifestations of strict settlement, a system that would dominate English property law for centuries and systematically subordinate women's inheritance claims to family continuity goals. You're also noticing changing attitudes about women's legal capacity more broadly. Where medieval law acknowledged women's legal incompetence, but carved out practical exceptions, early modern law was building more comprehensive, theoretically consistent systems that reduced exceptions and anomalies. The feme-sole trader status that let urban merchant women operate semi-independently was declining as guilds weakened and capitalist economic organisation replaced medieval corporate structures. Religious widows' economic power had been destroyed. Dower was being replaced by jointure. The various cracks and exceptions that allowed medieval women to exercise some property control were being systematically closed in the name of legal rationalisation and efficiency. Political centralisation also mattered, as royal courts and common law systems became more dominant, reducing the importance of local custom and manor courts. The variation that had characterised medieval property law diminished. Local customs that protected women generously in some regions were overridden by common law rules that might be less favourable. The patchwork was becoming more uniform, and uniformity meant fewer places where women could find advantageous local rules to defend their interests. Standardisation sounds neutral, even progressive, but its effect was to eliminate some of the more woman-friendly local variations that had survived precisely because they were local and customary rather than part of the formal legal system. You think about your grandmother, who lived under older customs where dower was truly automatic and unquestioned. You think about your daughter, who's negotiating a jointure that you privately believe is inadequate but she accepts as normal. 3 generations, 3 different property regimes, with rights flowing steadily away from women toward male heirs and husband-controlled settlements. The trajectory is clear and discouraging. You can't stop it. You're one widow in one small corner of a vast changing world, but you can witness it, name it, and refuse to pretend that modernization and rationalization are neutral technical improvements rather than politically charged changes that redistribute power from women to men. Tonight, as you update your will, you're conscious of doing so in a more hostile legal environment than your grandmother knew. She could count on automatic dower. You had to fight for yours. Your daughter is negotiating hers away in exchange for promises that may or may not materialize. The law is evolving, and women are losing ground with each evolution. Progress, the lawyers call it. You have other words for it. Words you keep to yourself because arguing with the momentum of legal change feels like arguing with the tide. But you note it, document it in letters and diaries that might survive, leaving evidence for future generations that this progress looked different from where you sat, looked distinctly like regression, loss, and the systematic closure of options that medieval women, for all their constraints, had at least occasionally possessed. You're reading a modern law textbook in a library that smells of old paper and furniture polish, and your hands shake slightly as you recognize phrases that echo across centuries. The widow's right to elect against the will, marital property regimes, community property states, elective share statutes. The medieval past hasn't vanished. It's mutated, transformed, left genetic traces in contemporary law that most people never recognize. You're holding evidence that Dower's ghost still haunts the legal landscape, that the struggles medieval widows fought are still being fought in different vocabulary, and that the fundamental tension between individual rights and family continuity that shaped medieval property law remains unresolved. Welcome to the uncomfortable realization that history isn't safely contained in the past, but bleeds continuously into the present, shaping lives today through legal structures built on medieval foundations. The common law dower system that defined your life survived, in various forms, well into the 20th century across much of the United States and other common law jurisdictions. American states inherited English property law, including dower and its male equivalent courtesy, and modified them slowly over centuries. As late as the 1970s and 1980s, some states still had dower statutes on the books, granting widows automatic interests in deceased husbands' property, regardless of what the will said. The specific rules varied. Some states gave 1/3, others gave different fractions. Some applied only to real estate while others included personal property. But the core principle remained. A spouse couldn't be completely disinherited. Law guaranteed surviving partners some minimum share. Medieval dower had evolved but not disappeared. Modern elective share statutes that exist in most UKIS states today are dowers' direct descendants. These laws typically allow a surviving spouse to elect to take a statutory share of the deceased spouse's estate, often 1/3 or 1/2, regardless of what the will provides. If your spouse tries to disinherit you completely, you can reject the will and claim your elective share instead. It's the same logic that protected medieval widows. Marriage creates mutual economic obligations that survive death, and law should prevent one spouse from leaving the other destitute. The mechanics have changed. You're not automatically receiving 1/3 of specific lands, but rather a share of the total estate calculated in complex ways. But the underlying principle is identical to medieval dower. Community property systems, used in several US states and derived from Spanish and French civil law traditions, represent a different evolution of medieval concerns. Under community property rules, property acquired during marriage belongs equally to both spouses, and upon death or divorce, each is entitled to half. It's conceptually different from dower, not a fraction reserved for widowhood but equal ongoing ownership during marriage. Yet, it addresses similar concerns about ensuring both spouses benefit from marital economic production. Historians still argue about whether community property systems offer better protection than common law dower elective share systems, but both acknowledge that marriage creates property rights that law must define and enforce. The struggles you see in modern divorce law also echo medieval property battles. Equitable distribution of marital property, alimony calculations, prenuptial agreements negotiating around default legal rules, all of these involve the same fundamental questions medieval women faced. How should property be divided when a marriage ends? What obligations do spouses owe each other economically? Can those obligations be negotiated away? Or should law impose minimum standards? Modern lawyers debate these questions with the same intensity medieval lawyers brought to dower disputes, suggesting the problems are genuinely difficult and perhaps unsolvable in ways that satisfy everyone. Prenuptial agreements are particularly interesting echoes of medieval jointure. Remember how jointure let couples negotiate away automatic dower in favour of agreed-upon settlements? Modern prenups do exactly the same thing. Allow couples to opt out of default property rules and create customised arrangements. And modern prenups face similar criticisms to those levelled at jointure. They're negotiated when parties have unequal bargaining power. They're often presented as take-it-or-leave-it conditions for marriage. They may be signed without full understanding of legal rights being waived, and they tend to favour the wealthier or more sophisticated party. The solutions medieval law attempted: separate, examination of the wife, requirements of free consent, limits on what can be waived, reappear in modern rules about prenup validity. Same problems, similar attempted solutions, ongoing arguments about whether the solutions actually work. One quirky modern echo: some jurisdictions recognise palimony claims by unmarried cohabitants, essentially arguing that long-term domestic partnerships create quasi-marital property rights, even without formal marriage. It's a controversial extension of marital property principles, but it reflects the same impulse that drove medieval dower: the recognition that people who build lives together deserve some protection when separation occurs, and that property rights shouldn't depend entirely on formal legal ceremonies. Medieval law would find this concept bizarre. Marriage was marriage, and everything else was something categorically different. But the underlying logic that economic interdependence creates obligations would be familiar. Gender-neutral application of these rules is a genuinely modern development. Medieval dower protected widows specifically. Widowers had different rules under courtesy that reflected different assumptions about men's and women's economic roles. Modern elective share and community property rules apply equally regardless of spouse's gender. At least in theory, same-sex marriages operate under the same property rules as different-sex marriages. This equality represents real progress beyond medieval assumptions. Though historians note that formally equal rules can still produce unequal outcomes when spouses enter marriage with unequal resources or earning potential, suggesting that formal legal equality doesn't automatically produce substantive economic justice. The debates about property division at divorce parallel medieval widow heir conflicts more than most people realize. A divorcing spouse arguing for a larger share of marital property sounds remarkably similar to a medieval widow arguing for generous dower assessment. The opposing spouse defending their property against excessive claims sounds like a medieval heir arguing the widow's demands are unreasonable. Courts trying to balance competing claims of desert, need, contribution, and fairness face the same insoluble difficulties medieval judges encountered. There are no obviously correct answers, only different ways of distributing hardship and benefit that advantage different parties depending on which principles you prioritize. Retirement benefits and pension rights create particularly complex modern parallels. In many jurisdictions, pensions earned during marriage are considered marital property subject to division. Giving the non-earning spouse rights to part of the other spouse's pension is conceptually similar to dower, recognition that the non-earning spouse contributed to the household and deserves to share in its benefits, but applied to modern employment structures rather than agricultural estates. The fights over pension division, with actuaries calculating present values and lawyers arguing about fair distribution, would bemuse medieval dowers, but the fundamental conflict over who deserves what would be immediately recognizable. You set down the law book and walk outside where the contemporary world hums with traffic and electricity and technologies your medieval ancestors couldn't imagine, but the legal questions they grappled with, how to balance individual rights against family continuity, how to protect vulnerable spouses without undermining the institution of marriage, how much freedom couples should have to negotiate their own arrangements versus how much law should impose minimum standards, remain unresolved. The medieval past isn't dead, it's not even past. To borrow a phrase, it's living in statute books and court decisions and lawyers' arguments and the property disputes of divorcing couples in courtrooms across the modern world. Tonight, you think about the continuity and change braided together in legal history. Medieval widows fought for dower. Modern spouses fight for elective shares or equitable distribution. The vocabulary changed. The economic context transformed. Gender assumptions evolved. But the core conflicts over property, autonomy, and mutual obligation persist. Understanding medieval women's property struggles doesn't just illuminate the past, it clarifies the present, revealing that contemporary legal battles have deep roots, that the questions we're arguing about today have been argued for centuries, and that perhaps the reason we haven't resolved them is that they're genuinely difficult questions without perfect answers. History doesn't provide solutions, but it offers perspective, showing that the fight for fair property rights is long, ongoing, and worth continuing even when progress seems impossible or reversible. You're sitting by a window as autumn twilight fades to dark, a cup of warm cider growing cold between your hands, and you're thinking about what all of this means, this long, complicated journey through medieval women's property rights, through marriages and widowhoods, through courts and negotiations, and the endless defensive battle to keep what law promised but practice contested. The candle beside you flickers, casting shadows that dance across the account books you've finally closed for the day. Outside, you hear the evening sounds of your small estate. A dog barking, someone calling the chickens in, the creak of the mill wheel slowing. These are the sounds of property you control, of a life you've built in the space that widowhood created, and you're acutely aware of how precarious and precious this independence is. You think about all the women whose stories have woven through this exploration, the young bride watching her legal identity dissolve on her wedding day, learning that marriage meant erasure as well as partnership, the widow discovering that her husband's death paradoxically restored the personhood that marriage had suspended, finding herself suddenly visible to law again after years of coverture. The urban merchant wives who carved out commercial identities separate from their husbands, proving that even restrictive systems contained cracks where determined women could wedge themselves into something approaching autonomy. The Paston women managing estates and commanding servants and defending property with armed men, operating as de facto lords while legally remaining subordinate wives. Do you remember them all? These women navigating impossible systems with whatever tools they could grasp. The abbesses and queens flash through your mind too. Women who achieved real power through renunciation or royal connection, wielding authority that secular married women couldn't touch. They proved that medieval society could accept female leadership and competence when properly packaged, when channeled through acceptable narratives of religious devotion or maternal protection. Their success was both inspiring and frustrating. Inspiring because it showed what women could accomplish given opportunity. Frustrating because it revealed that society knew perfectly well that women could govern and manage and lead, but simply chose to deny them those opportunities in most circumstances. The capabilities were never the real issue. The issue was always about power and who got to exercise it. You think about the legal mechanics, dower and jointure, coverture and feme sole status, private examinations and writ procedures. These weren't just abstract doctrines, but lived realities that shaped women's daily choices and life trajectories. Whether you had automatic dower rights or negotiated jointure affected how much agency you could exercise in marriage, how you planned for the future, what risks you could afford to take in defending your interests. Whether you lived in a region with favourable customs or harsh ones affected your quality of life more than almost any personal characteristic. Law mattered enormously, and the women who understood law, who studied it informally, who hired good lawyers, who learned to manipulate its procedures, fared better than women who remained ignorant of the rules constraining and occasionally protecting them. The pattern of erosion you witnessed in your lifetime troubles you deeply. You watch protections that your grandmother took for granted become negotiable. Watched automatic rights transform into optional arrangements. Watched the legal landscape shift steadily against women's interests, while lawyers praised the changes as modernization and rationalization. You couldn't stop the changes, but you witnessed them, and that witnessing matters. Someone needs to remember that law wasn't always structured this way, that medieval women once had certain protections that later women lost, that progress isn't linear and rights can move backward as easily as forward. Your memories, your letters, your carefully maintained records, they're evidence of a different time when law was different, and that evidence might matter someday to women who will need to know that change is possible because change already happened. The parallels with modern law that you've glimpsed suggest that these struggles continue, just in different vocabulary. The fundamental tensions between individual autonomy and family obligation, between protection and subordination, between formal legal rights and practical power haven't been resolved. They've been reframed, re-argued, relitigated in every generation, with each era thinking it's found new solutions only to discover the same old problems wearing contemporary clothes. Perhaps that's the real lesson. There are no perfect systems, no final solutions, only ongoing negotiations about how to balance competing goods and distribute inevitable hardships. Medieval law didn't get it right, but neither has any subsequent system. We're all muddling through, trying to be a little more just than the generation before. You're tired now, bone-deep tired in the way that comes from years of vigilance and struggle. You've defended your dower, managed your properties, resisted pressure to remarry, navigated courts and lawyers and family politics, and built a life that's genuinely yours in ways that seemed impossible during your marriage. The victory is real but exhausting, and you're aware that when you die, your hard-won independence dies with you. The property returns to the male line. Your stepson or his heirs will absorb these lands back into the estate, and the temporary space of female authority that widowhood created will collapse. Your authority was always borrowed time, a pause between a male ownership rather than a permanent transfer of power. Understanding that doesn't diminish the value of what you've built, but it does add melancholy to the achievement. The candle burns lower, the shadows deepen, and outside your window the stars emerge one by one in the darkening sky. You think about the continuity of women's struggles across centuries. Medieval widows and modern divorcees fighting essentially similar battles for property rights and autonomy, separated by centuries but united by the common experience of navigating legal systems that weren't designed with their interests as primary concerns. You think about the particular courage it takes to fight for incremental improvements when you won't live to see larger victories, to defend your small portion knowing the system itself won't change in your lifetime. That's the work you've been doing. Not revolutionary change, but stubborn. Grinding defense of the possible. Protection of whatever space for female agency the system accidentally or grudgingly allows. There's peace in having fought well. Even if the war continues, you defended your rights, supported other widows in their struggles, left records that document women's experiences and legal strategies, and proved to yourself, if no one else, that women could master legal complexity and defend their interests with skill and determination. You weren't passive victims of coverture. You were active participants in a rigged game, playing as well as the rules allowed and sometimes better. That matters. Personal agency and dignity matter even within oppressive systems, and the medieval women who refused to surrender meekly, who learned law and hired lawyers and stood in courts defending their rights, they maintained human dignity in circumstances designed to crush it. The room grows darker still, the candle now just a stub, and you feel yourself drifting towards sleep, your mind loosening its grip on these complicated thoughts. Tomorrow there will be more property management, more decisions, more negotiations with tenants and stewards and neighbours. But tonight, in this quiet moment, you're simply a widow in late medieval Europe, sitting with the knowledge of how far women have come and how far there is yet to go, holding both the pride of what you've personally achieved and the sorrow of how little the larger system has changed. It's enough. Not everything you'd hoped for, but enough. The fight continues. But tonight, you can rest, and as your eyes grow heavy and the last of the candle's light wavers and dims, you let yourself imagine all the women who came before you and all who will come after. Generations of daughters and widows and wives navigating property and power with whatever tools each era provides. Their struggles connecting across time like threads in an endless tapestry. Each woman adding her own small strand to a pattern too large for any single person to see completely. The sound of the mill wheel has stopped now. The dog has ceased barking. Everything settling into the profound quiet of a medieval night when the world slows down and the boundary between past and present seems to thin and blur. You're both yourself and all the women whose stories have threaded through tonight, both particular and universal, both historically specific and timeless in the fundamental human struggle for dignity and autonomy, The stars outside your window shine with patient light that left them years ago and is only now reaching your eyes. Time itself becoming strange and fluid, medieval and modern blurring together, because the questions you've lived with are still being asked and the answers are still incomplete, and perhaps that's simply the nature of human law trying imperfectly to organise human life. Let yourself release these heavy thoughts now. Let them drift away like smoke from the extinguished candle. You've carried them far enough for one night. Other women will pick them up and carry them forward. The work continues, but your work tonight is done. You can rest now. Deeply and completely. The property is secure enough for tonight. The documents are filed. The accounts are balanced. Everything that needs tending has been tended to. And you can finally let yourself